I echo what Ethan said, and Ethan and I have discussed this, and we'll
I can't hear him.
explaining our reasons why.
All right. Thank you. Thank you, Chairman. I tried.
Okay, Mr. Kuban, how much time do you need to make your request for your interview status? I can't hear you, sir. I can't hear you, sir. It's kind to me. Well, I guess I'm take that part too.
Mr. Wasserman, I think
Yes.
you need to put your phone on mute because you're muted. Are you the 786-512 number?
Yes, that's what I'm speaking through.
No, I know,
Mute
but
it?
while you're not speaking, mute it. Thank you.
I still can't hear you, Mr. Kuban.
Mr. Kuban, you may want to do the same thing that Mr. Wasserman is doing and call in on your cell phone and we get to see you, but hear you through your cell phone.
Vicky, this is Ryan. Can you hear me? I just want to make sure I'm available.
Yes, we can hear you, but you're very soft-spoken today. So try and speak louder, okay?
That's rare. That's rare for me. Sorry
I
about
know.
that.
Mr. If you disconnect and reconnect again to Zoom, it might fix your audio issue. One 301-715-8592. 1-301-715-8592.
Vicky, can you hear me better now, or is it still soft-spoken?
It's a little better.
Thank you.
I think Mr. Kuban is in a bunker.
You feel better, Vicky?
I think my blood pressure went up a little. That's never happened to me.
I thought you were going to explode. You
Hold on a second. A little? Really?
A little.
No, but now don't embarrass me.
I've never seen Vicky so animated.
No, look at it.
Can you hear me now?
Red.
Yes, we can hear you now.
Okay, thank you. Yeah, so there was a problem with with something that I had plugged into the computer. So I'll make this very quick. And I guess, Madam Attorney, I guess the first question that I have is this for PZ1 and for PZ2, or are we doing these separately?
They're for, no, it's for both together.
Okay.
You're going to make your argument for both.
Because we asked to intervene on both. So I represent Alex Moskowitz, Rachel Cardello, Isaac Cudsey, as well as Bayshore in the Grove. Bayshore in the Grove has 24 members that own real property within 500 feet of the Villa Woodbine project. And so basically there are two different reasons that I believe that we are entitled to intervene. A would be the close proximity. Mr. Moskowitz lives or owns property adjacent to the Villa Woodbine project. Rachel Cardello lives across the street on the Tiger Tail side, and Isaac Codsey lives adjacent to the property as well. And like as I stated before, Bayshore in the Grove has 24 members that live within 500 feet or own real property within 500 feet of the project. That would give us intervenor status. If we would not get intervenor status, I can't think of any other set of circumstances that would warrant intervenor status other than, I mean, they live within 500 feet and they live adjacent to the property. So that right there, I believe would grant them. The second reason would be is that Mr. Carolio, Commissioner Carolio, has recused himself from this particular consideration of these two items. And the reason he did so was because he owned property. He didn't even live there, but he owns property within 500 feet. If he feels that it would be an ethical problem for him to participate in this, then I think that the same argument basically goes is that the people who live within 500 feet or adjacent to the property would have intervenor status. Obviously, they are going to suffer ills that are far different than what someone else would suffer. So if we look at the latest decision from the Circuit Appellate Court, they found that two of my clients who lived a mile away from the particular Playhouse project did not have standing. So that's very easily distinguishable here in that all of my clients basically live within 500 feet of the project. So there is no case directly on point for the city of Miami that talks about that you would not get intervenor status if you live adjacent to the property. And I'm not sure exactly what the circle would be. However, I know that the county's case talked about a particular house that was within 500 feet and then houses that were outside of the 500-foot radius. So in this particular case, as I said before, all of my clients live either adjacent to or within 500 feet, and therefore this commission should grant intervenor status because they will be affected differently than people that live outside of the 500 feet or into the mile area. Thank you.
Mr. Kuven, a conflict of interest between Commissioner Carollo and the status as an intervener. I mean, those are two very different issues. I mean, the standards are completely different. I mean, they're not one and the same. So can you tell me, I want you to describe that argument better for me so I can have an understanding of why you believe that they're one and the same and we should treat them differently. And then also the request that you made for intervening status just based upon the person who lives next door. I don't know if the case law just speaks to just simply proximity. There has to be more than that. So can you kind of describe that for me as well?
What is this?
Excuse me.
So this is a picture of the project and the location of the people who live either adjacent, and these are the interveners. And so we have the 500-foot radius. We have Mr. Codsey that lives right here adjacent to it. Mrs. Cardello that lives catty corner to it. And then we have Mr. Moskowitz that lives also adjacent to it here. Bayshore and Grove, persons that own properties that are members of Bayshore and Grove. We have Mr. Ferrano, we have Mr. Mailer, the Knowles, Ewings, Lazarus, Garcia Diaz, Ms. Chung, and Seguren that live all within, and these are members, these persons are all members of Bayshore and Grove and live within the 500-foot circumference surrounding the project.
Yeah, I'm sorry, Scott Silver, also on behalf of Mr. Moskowitz. We have some specific facts relating to his His property abuts the applicant's property for over 144 feet. The exit for the school is directly next to his front entry. So it actually enters, if you take, they're proposing solely a right turn onto Bayshore Drive, and that would directly cross his driveway. The massing of the auditorium and pool structures are immediately adjacent to his property, and because they cover most of the property, could create not only erosion, but also runoff and water intrusion into his property. The main building has 30,000 square feet, which also, because it's on the slope of the Silver Bluff, can cause further redirection of the water there. So as opposed to the impact to the general public, this one particular party, Mr. Moskowitz and his ownership would suffer a special impact and special damage as a result of it. Additionally, Mr. Kazi on the north side has hundreds of feet of direct impact, and the view plane that's being from his property, the view plane is being directly impacted. If you go from the back of his property looking forward, it would actually block views along that side, along his south side of his property, out towards Bayshore Drive. So those two parties who on either side, Moskowitz and Kazi, have direct impacts that are different from those that the general public would suffer. And I think that should be the standard that would be applied for intervener status. They're not just the general public. They have specific identifiable items that would be different than what the general public would suffer.
Good evening, commissioners. My name is Rachel Cardello. I live at 2175 Tiger Tail. So I just want to quickly touch base on a few bullet points to help sort of reiterate why we think the intervener status is applicable to us. The first one is being a resident on Tiger Tail Avenue and having recently done a renovation to my own house, I was required to have a setback on Tiger Tail at 30 feet, which is standard for that street. And you can see from the property and project being proposed, they're about under 20 feet on Tiger Tail. So my limitations of a property rights of what I could have renovated my home for has already been kind of compromised by what's happening across the street from me. Furthermore, the increased erosion that's potentially happening due to the lack of open space and green space, the canopy change will greatly deter from the amount of protection I get from the bay winds onto my house. And then further problems is the utility costs of lack of shading, the increase of insurance premium, because I anticipate there'd be further property damage to my home as a result of both the drainage issues and the loss of canopy.
And so there, you've heard from all three of the individuals that own property, and we have
How are you? I'm Isaac Kotze. I'm also a adjacent neighbor, 475 feet with this property. Clearly, I will be severely damaged by what's about to happen here from an environmental standpoint, tree mitigation, construction, and the impact of the school. So I will be completely different than most people, all citizens of Miami. Like, again, I'm repeating myself, 475 feet with this property. Thank you.
Good evening. My name is Rose Pujol. I live at 2455 South Bayshore Drive.
You are the president.
I am the co-founder, director. I don't like the title of president, but I can tell you that I have definitely helped put this group together. And one of the things that we originally did is we realized that the school, that first 6 months through Tucker Gibbs as their community activist, had been reaching out to some of the neighbors. And when they say reaching out, they reached out to 13 neighbors. So when we said from the very beginning that this was a stealth operation, since it had gone through the HEP board and did not require the notice procedures that having gone through PZAB, we said we have to do the work of PZAB here. So we knocked on doors. And I can tell you that of the doors that we knocked on, we have 24 that are on the list that Greenberg Traurig used. We used the same company for the notices that Greenberg Traurig was using, and 24 of those owners filed. We helped them file for intervener status. So they are members of our group. Now, when you ask us, maybe the people are not here tonight, we filed on behalf of the three
I'm gonna
who were the
interrupt.
most affected by this situation.
Okay.
So there, you see that we've spoken to, we've seen all three of the property owners, well, two of the property owners, and then Mr. Silver, who has spoken for Alice Moskowitz, who's not with us tonight. He's out of the state of Florida, and we've also spoken to the director of Bayshore and Grove. And so she has also elaborated the distance that they live from the project, and that they should be granted intervenor status.
Okay, now I want you to be very specific with me because you had a number of people speak and they didn't necessarily properly identify themselves. So I don't know who's an attorney, who's a witness, you know, I was able to decipher that. So when you say that someone is applying for intervenor status, I want you to clearly delineate right now who those individuals are. I'm not asking for anyone else to speak. I'm not asking for anyone else to speak. I want the attorney to tell me.
I'm sorry, the two people that spoke. So we have Rachel Cardello.
Okay.
We have Isaac Kotze, and then we have Scott Silver, who's an attorney who represents Mr. Moskowitz as well as myself, who has spoken. And
We have Alex Moskowitz.
Mr. Moskowitz is on the phone. Go
Right.
ahead. I'll see if we
No,
can.
you don't, because he couldn't be sworn in. So
Okay. You want me to swear them in?
no, you're not going to be able to swear them in.
Mr. Moskowitz has forwarded. Mr. Moskowitz, I have forwarded Mr. Moskowitz sworn his two affidavits. I am a notary public, and I can swear these other two individuals if you'd like me to swear them right now and have them retestify if you like.
No, I think we took the testimony. We took we swore people in earlier today, so that's not the issue. I just wanted to be clear on the record exactly who it was. I can't. Whoever's on the phone with you, I can't identify. Right? I can't see them. I don't know who that person is. No matter if they swear that that's them or not, there's no way that I can tell that. But nonetheless, are you finished with your presentation?
Yeah, I've asked, Chair, I've sent several emails to the city of Miami asking for a link for Mr. Moskowitz, but I haven't been provided with the link. I believe Mr. Moskowitz has a copy of my link
That's
he
fine,
may have.
The attorney spoke on his behalf, right? So it's captured on the record.
Do you want, can he get on the link with?
If someone will activate his link and bring him into the meeting, he's already been sworn. He's submitted his affidavits, and I think he's activated the link. I just think that nobody has let him into the meeting.
He's not the attorney. He's the client, correct?
He filed an affidavit.
Yes, he filed two affidavits. I sent both affidavits to the city attorneys, to Ms. Ketterman, I believe it was, as
And
well
you're
as the
speaking,
supplemental.
are you speaking on his behalf? Are you representing him?
Yes.
Yes. Yes.
Okay, then we're fine. If you're finished with your presentation, I'll move on to Mr. Balin.
Thank you. May I proceed? Can you hear me?
Yes.
Yes, we can hear you, Alex.
Okay, thank you. For the record, Ethan Wasserman with Greenberg Traurig 333 Southeast 2nd Avenue, here on behalf of the applicant and the appellant in this case. We object to the request for intervenor status in this matter. Intervenor is clearly a creature of code, and it's not allowed in Chapter 23 or Chapter 17. The city attorney has stated this in prior hearings. I believe she mentioned it again this evening. This is not a new issue. The intervenor status requested in writing by the opposition references Miami 21 code provisions, which again is not the correct citations as they do not cover HEP applications. Miami 21 is very explicit as to what hearings authorize intervenor status, including exceptions, variances, special area plans, or rezonings. Even though intervenor status is clearly not appropriate for this application, I do want to at least mention that if you were to look in Miami 21, intervener is defined in Miami 21 as a person whose interests are adversely affected in a manner greater than the general public. As a HEP application without any variances or other relief from the code, we are proceeding with what would otherwise be considered an as-of-right development, and in actuality, we are not maxing out our development potential. Therefore, there is no harm to anyone from this preservation application. We are preserving the historic features of the property, we're adding trees to the property, and we're building with a design that is compatible with the historic architecture of Villa Woodbine that's on the property today. There is no harm suffered by an individual neighbor, and certainly no harm different from the general public. Neighbors, by virtue of proximity alone, does not grant party status. The neighbors have an opportunity to be heard in public comments, and that is what Florida law allows. To the extent this commission wants to grant opposing counsel a few extra minutes for a presentation, I would not object to that. But full party status, which is essentially what's being requested here, is unreasonable in this matter, and it's not supported by law. I do want to cite to a case that I think is very helpful to help guide this discussion. Carillon Community Residential versus Seminole County is a great case decided that explains the distinction between a party and a participant. A party is granted full rights to present, cross-examine, et cetera, et cetera. A participant has rights to a lesser degree, including presenting before the board, providing their testimony, and lodging their position. Florida law has no requirement to allow cross-examination, for example, to every participant in a hearing. On policy reasons alone, we can understand that. It would lead to an impractical procedure allowing every participant the right to cross-examine or to make significant or lengthy presentations. And I do want to read a quote, if you'll indulge me, from this case. And I quote, "Oftentimes, such quasi-judicial hearings are attended by more than just the parties. They are open to the public. In the case of rezoning hearings, neighboring landowners may attend and want to be heard on a proposed zoning change to a nearby property. Our court has previously stated that a participant in a quasi-judicial proceeding is clearly entitled to some measure of due process. The issue of what process is due depends on the function of the proceeding as well as the nature of the interest affected." There's a citation there. Petitioners incorrectly assert that Florida law requires that all participants in quasi-judicial proceedings be allowed to cross-examine witnesses. Florida law has no such requirement, end quote. So for the record, we must lodge our objection as we do not believe there is any basis to grant these individuals party status. My client is the appellant in this case. Opposing parties are not the appellees. It's important to mention opposing counsel had filed an appeal based on not being granted intervener status at the HEP hearing. That appeal was rejected by the city attorney's office. In the rejection, the city stated on January 10th, 2020 in a letter that Chapter 17 does not contain intervener status and that intervener status is not an appealable decision to the city commission. The letter further states that Mr. Kubin's clients are not aggrieved parties, and we will submit that letter into the record. We are asking you to stick to your code. There is no intervener option in Chapter 23 or a Chapter 17 hearing. Turning to the specifics that were just raised before me, the opponents have raised the right to a view corridor. A view corridor is not protected by Florida law. Drainage onto a neighboring property owner. Quite frankly, I'm not aware that we're allowed to do that by law. So there really can't be a claim that we're going to do that, and nothing in our plans or the application gives rise to that effect. The scope of our application is important here to understand the nature of the potential impacts to neighbors. This is not a variance. This is not a special area plan. This is not a rezoning. This is not a waiver. No special exceptions or any other granting of relief from the code requirements. To the contrary, this is essentially an as-of-right site plan approval meeting all code requirements, but we go before we are subject to Chapter 17 and subject to Chapter 23. No individual neighbor is affected, as in the case where there is a request for setback relief or a change of use. We fully concede that there is a companion exception application for school use, and that will certainly cover activities on site, including traffic. But that is not before you today, notwithstanding the many, many comments in the record this morning. We are seeking an as-of-right design with no impact on these specific neighbors and certainly no impact different than the general public. Any other conclusion would grant every neighbor in the city party status to every development application, building permit, or home renovation in the city. That concludes my presentation.
Picking up on what Ethan said, and I know that my audio is not the best this evening, which is rare for me, but we would ask that the city follow their own law and not grant intervener status under sections of the code where it doesn't exist. Thank you very much.
So I'll give a little bit of time for, well, I'm sorry. is there a position that the city administration has, or are you not involved in this debate?
No, sir. Thank you. Glad to defer to the city attorney's office.
Okay, but before we go to the city attorney's office, I want to hear. No, I'll hear you now, Victoria, because when we rebut, I'll allow Mr. Kuban to be able to comment on what you replied as well.
Chairman, typically, I think that a court of law would potentially have this as an appellate issue if they weren't granted intervenor status. However, the arguments that Mr. Balin and Mr. Wasserman state are correct. Our HEP rules does not have a intervenor status per code. This could be something that is looked at via case law and not per code. In the zoning exception, because we do have cases, the cases that we have had intervenor status in the past have been zoning matters. And through the exception process or what have you, and the cases that we've talked about before, Reynard v. Dade County and Southwest Ranches v. County of Broward, it talks about an individual having standing to challenge zoning actions when they have an interest exceeding the general interest of the community. So obviously in a zoning context, that is the case law. However, and that's why I asked the applicants about their willingness to agree to party status, because I think it's something that a court may, when they are the next door neighbors, they abut all sides of the property. And it is something, I think it's a decision that you can make based on what you've heard. But the code itself, the HEP portion of our code, chapters 17, 23, they do not provide automatic intervenor status. They would have to show a special injury. They did state some of the things that they felt that it would be cause an injury. But again, this is something that you can determine. If this were a zoning matter, it would be very clear cut. However, I do think that a court may look at it just based on their proximity. Mr. Kuban, did they all receive notice? All the people that are with you today?
But can I just pick up on something that the city attorney said, because I agree with her, and that is, suggesting an injury or suggesting some special.
Ryan, you're very, very low.
I'm sorry, suggesting it.
Yeah, lean forward.
Suggesting an injury or an injury or suggesting certain.
I can't hear.
We can't hear you. Lean forward.
Okay, give me 1 moment. No problem. Is that better?
Yes.
I agree with something Ms. Mendez just said, and that is, under the code, suggesting an injury is vastly different than alleging one, and that's why this.
I still can't hear.
To their intervenor status.
What he said on the record was suggesting an injury is still not having one. Is that what you said?
That's exactly what I said. Yes.
Okay.
Sorry, you can't hear me, Commissioner.
No, I understand. He says suggesting an injury is still not having one, because remember that there was supposed to be a special injury in how you.
I got it.
May I speak?
Not at the moment, sir. Madam City Attorney?
Yes, Chairman.
Are you finished?
Yes.
Okay.
The only thing I had asked Mr. Kuban, and I don't know if he said it, if all of his clients and that of his co-counsel, if they all received notice within 500 feet.
The answer is yes.
Okay, Mr. Kuban, this is your opportunity for a brief rebuttal. If you have any information that you want to pull from Mr. Moskowitz, you can.
I do. I'd like to say to Mr. Wasserman is that his argument that we were not granted intervenor status in the HEP board and therefore we should not be granted intervenor status now really has no foundation in law. It's just his feeling or his thought. If you look at the code specifically, it says that intervener shall mean a person whose interest in the public in the proceedings are adversely affected in a manner greater those than the general public. This is coming from Miami 21. A party shall mean an applicant, the city staff, or any person recognized by the decision-making body as a qualified intervener, which means that that decision relies upon you, the commissioners for the city of Miami. If you can't think of a circumstance where someone abutted the property and that they have stated clearly that they will be affected differently. Of course, Mr. Wasserman started to argue his case. I'm not arguing the case and saying that they are, that the sky is falling. He said they will not be adversely affected by this particular structure because it's a fabulous structure and it's going to do great. However, what's the harm in allowing these people to intervene? This is government. They all received notice. They live adjacent to the property. They live within the 500-foot boundary of the property. And to be honest with you, if this particular intervener status is not granted, then this particular matter will go to the circuit court, and which I believe that the circuit court will grant them intervener status, and then we can come and do this all over again. They are entitled to intervener status. They are entitled to cross-examine witnesses. They are entitled to present evidence as well as their own experts. You shouldn't just take the applicant's word for it. Again, this is by the government for the people, and so the people that live adjacent to the property are the people who are being affected the most and differently than the general public should be able to intervene. Mr. Silverman,
yes, and further specifically as to Mr. Moskowitz, through the submission of the affidavits, we've presented evidence as to his special injury. The applicant has only presented the statements of the attorney. So we've presented the evidence of the special damage, and they have done nothing to rebut it. So as a matter of law, I would say that we've presented sufficient evidence for his intervener status.
And if I could just relinquish 2 minutes of my time to Mr. Moskowitz, I believe he's here. Is he here? Scott, are you here?
Yes, he's there.
He is here. Mr. Clerk, has Mr. Moskowitz been sworn in?
Remember, Chairman, that we did the special.
Earlier, but I don't know if Mr. Moskowitz was a part of those.
Right, but we did the changes so that the interveners or appellate counsel can swear in their own witnesses.
Okay.
And I believe Mr. Kuven says that he has the affidavits from Mr. Moskowitz and swore him in earlier. Mr. Kuven, can you confirm?
I can confirm that I received 2 affidavits from Mr. Moskowitz, and I have forwarded them to the city.
Thank you so much.
Right. You want to direct your witness?
Mr. Chair, will I have an opportunity to respond? Is this rebuttal or new testimony being presented?
Well, this is, he's in rebuttal. I don't know just yet if it's new testimony, but this is his rebuttal time, so I'm allowing him the flexibility to bring up Mr. Moskowitz. I'm sorry, it's Moskowitz.
Moskowitz, you said it right. Sorry, my speaker cut out for a little bit, so I apologize. Thank you. I appreciate that, Mr. Chair, Commissioners. Mr. Kuven, I think, summed up essentially my points. I did want to just make it clear that it's certainly within the authority, as the city attorney had pointed out, for the commission to grant us intervener status, as section 7.1.4.3G states that within Miami 21 that you guys are in fact the decision-making body authorized to grant me intervener status. Moreover, it's worth noting when I'd spoken with Mr. Warren Adams, the preservation officer for the HEP board, more than half a year ago when I first requested intervener status be granted, he actually told me this isn't the right form, but when it comes time, when and if it comes time that you need to appeal it, the city commission is in fact the right authority to grant intervener status. And so at this point, it's a little frustrating to hear one government entity say it should be a different government entity, and then, potentially face this entity saying, sorry, there's just no opportunity for you to be recognized as someone who could be injured more than other parties. And I shouldn't have to prove that fact more than saying I directly abut the beautiful wall you see here behind me is in fact the property adjacent to the Villa Woodbine property that sits next to my house. So I can't show it better than a picture, but I have 144 feet of adjacency with them. This is directly relevant to me more than just general people in the community. You look at their plans, everything is relevant to me. You can say whether it's on the environmental stuff, on the archaeological ground digging aspects, on the traffic component, which they might argue aren't relevant to HEP board. I have a different perspective and have people who will suggest otherwise, but that's all getting into it. I really would like this board, this commission, to give me the opportunity to be able to provide appropriate responses. Thank you.
May I quickly respond?
I'm going to allow you to respond. And Madam City Attorney, I'm kind of confused because even if he's an
the sections of the code.
Go ahead.
The sections of the code, and this is why I tried to, and I apologize if I was not articulate. I tried to describe the HEP code pursuant to Chapter 23 and our Miami 21 code, which has to do with zoning. The sections that they are describing have to do with the Miami 21 code and intervener status with regard to the Miami 21 code. So I just wanted to make sure that we were clear on that HEP does not provide, the HEP portions of our code do not provide any intervener status. So you have to show injury, according to our case law and what have you. The zoning portion under Miami 21 does. However, as I said, when we were talking about this, the courts may still, because these individuals are so close to the property and have alleged injury, courts may have a different take on that, but still the commission is the one that makes that determination based on everything that they have heard thus far.
Mr. Balin?
You're on mute.
Yeah, you're on mute. I'm trying to unmute you, but I can't.
Is this audio better, everyone? I apologize.
Yes. Yes.
I agree with this. Finally, I'm as loud as I usually am, so thank you, everyone. I agree with what the city attorney and Ethan agrees with the city attorney are saying. The folks this evening are quoting from a code that is that's not what we're here tonight for. We're here for Chapter 23 and Chapter 17, and they are correctly citing to Miami 21, which is not applicable this evening. So we would respectfully ask that you would not grant them intervener status, and to the extent, and I value Victoria's opinion, to the extent in the future a court of law was to say that we're to rule that they may, based on standing or based on some other standard that's not before this commission tonight, be granted some special status, that's fine. Again, as Ethan led off with, Chairman, if you want to give them and the Vice Chairman and the Commission say, Mr. Bayline, we respect everything you're saying and legally we understand you, and Ms. Mendez, we'd like to give them a few extra minutes to meditation or to speak further, I have no problem with that, and all good. But from a legal perspective, we just want to make sure that if the issues before the board this evening, from a legal perspective, we want to make sure we're addressing them, and from a substantive perspective, we want to make sure we're not using Miami 21, which is not before the board, the commission this evening, to grant folks rights that may or may not happen. Respectfully.
Thank you, sir.
And if I just may point out one thing, please, just very quickly, is that if you look at the Playhouse 1 case, the circuit court rejected intervener status based on the distance that the interveners lived from the property. They did not reject it based on what Mr. Wasserman is saying or any of the other legal arguments that they didn't cite the right statute or this right code or anything else. If the court had rejected it because of that, they would have said so. They rejected it specifically because they lived a mile away and they didn't live adjacent or within the 500-foot property limit.
Yeah, but Counselor, I mean, you're saying that they may not have gotten to that argument. So, for instance, the court denied it because they were a mile away. Then could it be possible? I'm asking you that they're saying that we don't even have to look at special injury because they're so far away that there could not have been a special injury. I mean, so just because you're close, you still have to allege special injury.
And I believe they have, Mr. Chair.
Right. Thank you. Is there anyone from the commission that'd like to make a comment about any of this? Mr.
Yes,
Russell?
Mr. Chairman.
Excuse me.
Thank you, Mr. Chairman. I want to fully understand what our city attorney was expressing with regard to the difference between Chapter 23 and Miami 21 when it comes to appeals. Whatever we decide in this body, we need it to be bulletproof to a higher court of law. And if we are delinquent in procedure in some way, then our overall decision will be found faulty. So I just want to make sure we're getting this part correct. We've got to lay the right foundation so we can build this case and listen appropriately and make the right decision. So, Madam City Attorney, are you saying that under Chapter 23, there is not necessarily intervener status, but in Miami 21, there is under an appeal situation, even though that appeal is of an issue in in Chapter 23? So which standard should we be following for intervener status? The Chapter 23 because it's a Chapter 23 issue, or Miami 21 because it is an appeal under Miami 21?
So I wanted to point out, Chapter 23 does not have anything with regard to intervener status. Miami 21 does. However, Miami 21 is not here before you today because this is not a zoning matter. What I started off by saying was that under common law, if the cases of Reynard, Southwest Ranches, those type of cases say that people that are aggrieved parties need to show a special injury. They need to show that it's greater, their interest is greater than that of the general public. So these types of reasons are the ones that at common law would give these individuals standing to deal with this case on an intervener status. What I wanted to let you know is that there is nothing in our HEP code that allows that. Now, I will tell you that I believe in the Playhouse appeal, which was also a HEP situation, we did allow interveners. You allowed interveners. The commission allowed interveners at that time because they had demonstrated some sort of special injury, and that so I want you to know that you can make that decision based on everything that you've heard here today. And as you rightly pointed out, a court of law will potentially want to give this opportunity to interveners. And yes, we may be back here again, as Mr. Kubin said. Even though the court in the Playhouse reversed, you as the commission did allow the interveners, but the court in Playhouse said these guys were too far away. They're a mile away. These individuals that you've heard speak today are hugging the property. It's a little different.
Thank you.
So in your opinion, am I may, Mr. Chair?
You recognize, sir.
Thank you. Madam Attorney, in your opinion, a court will allow, or if we decide not to, give them intervener status? In your opinion, your legal opinion, a court will give them intervener status?
Based on a court would, yes, give them.
In your opinion?
Yes.
But just to clarify, a court cannot give them intervener status. A court can just throw out our decision based on making a decision without having given them intervener status.
Throw out our decision because we did not give them intervener.
Correct. That's
sorry.
We're saying the same thing. Okay.
Yeah, 601.
Can I ask a clarification? So, City Attorney, the cases, the Renard cases, the Playhouse, that was an issue of intervener, or that was an issue of those are standing cases to appeal? Does someone have standing to appeal?
Yes, but those are the cases in a zoning context. And unfortunately, this is a HEP context, a zoning context. Is in order to give some sort of something
But that's
for the
different,
commission.
but that's different, right? I mean, you gave a
Vastly.
legal opinion.
Vastly different.
Yeah, of course it is. You gave a legal opinion based on, this is not a zoning issue we're dealing with today. So your opinion is based on the court will do it, how we've been dealing with a zoning issue, a zoning matter.
So what I've said is that these are zoning issues versus HEP issues. Today, we're dealing with a HEP issue. There is nothing on point that allows for them to automatically come in. They have to prove some sort of injury.
That part I understand. That's not what I asked you. That part I understand. What I asked you was what your legal opinion was as to what a court would do if we denied them intervenor status. You cited a case or an example that deals with a zoning matter. This is not a zoning matter.
No, I didn't. So I didn't cite the case for the proposition that it would be allowed in a HEP case. I cited it for the proposition for you to know what happens in zoning matters.
Correct. So what happens in, do you have an example what happens in a HEP matter or a matter of, you don't have any example like that?
There is no cases on point in the HEP context, and that's where everybody started
right.
discussing this.
So the fact of the matter is that you don't know what a court will do.
It's just based on the things that they take into account with regard to proximity, special injury, the fact that, they will be affected more than the general public. Those are the things that a court would take into account if these people are not given the opportunity. And that's why I started this whole process with, would they agree to at least allow them to participate? With that said, it's still your factual decision to make. I just suggest that
but we like to make factual decisions based on facts. That's why I'm asking the questions, right?
Right. So the best example that I could give you is the HEP case that we just won on appeal with regard to Playhouse, or at least the other Playhouse case that had to do with the court did not think they were proper interveners because they were too far away, not because it was a HEP case. Okay. So that I'm just, it's all we have right now.
Question, and it's very simple. From what I understand from all the things that you have said, it is that in this case, what we have in front of us, what we are deciding to now, does not, the intervening status, it does not apply. If we were changing the code, it was a code change. I mean, if we were changing the code to build the school, then it will apply. And that by us granting intervening status, it doesn't, it's not because it applies to a HEP case, which is what we are hearing here today. So I want to question, I want you to answer yes or no. Is this just a HEP decision on what we're doing here? According to this, what I'm reading here, it is reversing or affirming, modifying the decision of Miami Historic and Preservation Board. You see, what we are dealing today is if we are going to affirm or deny the decision of the Historic Preservation Board. Right. And I don't see how that intervening status. You can tie that. In this case, in other cases, you don't do it. You see, and because I do understand when you have a zoning change that there are people that could be affected by that positively or negatively from that zoning change and a building that is. But that should be the next step on this application. You see, not today. The next step in this application is the one that we should be considering if they have intervening status. That is my take on this.
I agree with that. Mr. Chair, I'm sorry. Mr. Chair, through you.
Yes.
I'd like Mr. Bailey to take a shot at this. Your thoughts?
Commissioners, I have to tell you, I agree with both Commissioner Reyes. I agree with you, Commissioner Diaz de la Portilla, that if this was a zoning matter, for us to object to intervener status, I think would be a bit, dare I say, laughable. But under Chapter 23 and Chapter 17, I agree with both you and Commissioner Reyes that if the, and again, I don't pretend to be your attorney. I understand that you have, more than competent counsel. But my take on this and the app as on behalf of Carrollton, if the city was to grant intervenor status this evening under Chapter 23 and Chapter 17, I think that you would be almost rewriting your code, kind of as Commissioner Reyes said, and I agree with the two of you on this topic. If we were here on a zoning application, which very candidly, I hope we are before this commission in several months from now on a zoning application, you could lay off the screen if we're on a screen, or laugh me out of City Hall for saying no intervenor. But under these chapters of the code, I agree with you.
So you would agree. So you would agree that when we come back for the zoning application, that we're not there yet, but when we do come back, that they will be granted intervenor status. You would not object to that.
I think it would be very difficult for us to object to that, given the facts that I'm assuming at the time. Yes.
That's fair enough. Okay.
And if that at that time it's the zoning matter, but I think that
I got that. But I would like to hear Mr. Kubin, maybe if Mr. Chairman, if I may, I would like to hear Mr. Kubin's response to Mr. Bailey, just to get kind of different perspectives.
So just like Mr. Bellion said, is that this is the change of use is exactly what they are seeking here. And, I don't have to get off the turnpike to be on my way to Disney World. So once I get on the turnpike here in Miami, or once I leave the front of my house and I'm on my way to Disney World, I don't have to get off at the exit there in Orlando to say, okay, now I'm on my way to Disney World. No, he has admitted that he is looking for a change of use, that this all leads exactly what he wants, which is a zoning change of the property. And so that's why he had to go to the HEP board. His application was for a zoning change. While they may examine different things at the HEP board, and they may examine different things at the zoning boards, it's still all the same. They're all on the road to Disney World. They're all looking for it.
But you do agree that there's a process, right, in place, and there's certain steps. There's step 1, and step 2, and step 3. You're on the road to Disney World, but there's some exits along the way, right? So it's a process. You don't apply the same standard. It's not an express, right? It's a kind of, you can exit whenever you want, right? So I don't think it's a fair analogy you're trying to make here. Is it in fact a process in your mind, Mr. Kubin, and they have a good, strong legal argument that you should not be granted intervenor status at this juncture in this way along the road, this point along the road?
Well, actually, if I cite back to the code again and I read it, the first thing, and this is one of the arguments that I did make to the city, was that there's nothing here that prohibits this commission from granting status.
That's not what we argue.
That's not the point. That's not the point.
The point is if we should be considering, intervenor status or not. That's the point.
We can do whatever we want. We're saying what should be the correct thing to do, right?
Absolutely.
At the end of the day, what's a legal process? And is there any case law to support it one way or the other? Are we operating in a zoning situation, or operating in an appeal situation to the HEP board? And we know what part of the road we're in right now, right? So give me your legal argument why you should be granted legal intervenor status right now at this juncture.
My legal argument would be is that the code allows you to do it, and I believe that this commission would want to know all the facts and to hear contrasting opinions from different experts regarding the property and the HEP board appeal.
But you do understand that we will eventually, when we get to that point of the road, that we will eventually hear all the facts, because
we won't be able to go back and revisit this ever again once we get past the appeal. So if you grant the appeal, and we will not be able to go back and to talk about trees, we will not be able to go back and talk about.
No, you'll be able to talk about zoning. So you'll be able to talk about zoning, and the fact of the matter is that it can't be built. Whatever the end game is for them, right, to build something, it cannot be built unless they go through the zoning changes, right? So you will have an opportunity to eventually be able to make your arguments and have intervenor status and grant an intervenor status and make all the arguments that you are trying to make now. I think a little bit prematurely.
Excuse me a minute, but you're assuming that this is going to pass. I mean, you're going to have that the appellant is going to have the votes in order to approve the appeal, and that might not be the case. I mean, and that I'm not at that stage yet. What I'm deciding is the intervening status, if it does apply now or not. Now, the appeal is something else. The appeal is a different vote, you see? And you are assuming that if you are not granted intervening status, but I mean that the appeal is lost, and that is not the case. And besides, even if you lose, we vote against the appeal, they can come back again with a different proposal and taking different steps as they did now. I mean, this is not what you're saying, sir. It's not what we are dealing with now. We are dealing with the intervening status. Is it proper or not? And that's it. I mean, in my opinion, that's my opinion. But the appeal, the vote on the appeal in favor or against is not under discussion now. You see? It is the intervening status.
One other legal argument on behalf of Alex.
1 second,
An appeal of a HEP board.
Mr. Vice Chairman.
Thank you, Mr. Chairman. I see where the commissioners are coming from on this one, but I want to really paint the broader picture. If we have, it is within our jurisdiction to grant intervenor status, and by precedent, we have done so before on appeals of a HEP board decision. I don't think it's right for us to selectively say not to grant intervenor status just on the basis that this is a HEP board decision that we're appealing, that's being appealed at this point. Clearly, we've set the precedent that we can and have granted intervenor status in the past.
When was that? When was that? A long time ago?
The Playhouse.
The Playhouse?
On the Playhouse.
I wasn't here, so.
Sure, but there were two residents that were that requested intervenor
I know what
status.
happened, but I'm saying that I wasn't here.
But they were not granted intervening status.
They were granted
Mr. Vice Chairman,
by our body.
Okay, but that's
Vice Chairman and Madam City Attorney, was the argument made at that hearing though that intervenor status should not be granted because it was a different part of the section? Or is this a new argument that we're hearing today?
Okay, I'm trying to pull the case because unfortunately we don't, it's not reported on Westlaw, I believe. So we're trying to pull the case. I'm trying to see if they were appellants or interveners. So just give me
I think it was a
moment. This was not.
You could be right.
But didn't the court overrule the granting of the status?
I believe
As
so.
Mr. Kuvan pointed out.
I am trying to check if it is
No
if
problem.
they were appellants or interveners.
We'll wait.
The point
We'll
is,
wait.
right. The point is, if you want to hear it, you can. If you don't, you can leave it
We
to
know
the
that.
zoning.
No,
You
yeah,
can
we
leave it for
understand
the
that.
zoning.
But
My
We
point-
understand that. We just want you to look at, give us what you're researching right now. I like to make decisions based on information. So,
Yeah.
Bells, I'm willing to wait for you to give us an answer.
Okay,
Yeah,
and,
but I wasn't finished on my
if I
point.
can, then we need like a 5-minute break. I think my blood pressure is like high. From
no, I can see it. I can see it.
I just need 5 minutes. If we can and research it, I'll research it and get right back to you.
All right, and Madam City Attorney, I don't know if you were able to tell us from that hearing if anyone made a similar argument as Mr. Bailey and Mr. Washington are making right now, which is that that this section of the rules that we're considering right now through the HEP board does not allow for intervenor status, or is silent to that of intervenor status as compared to the Miami 21.
Yeah, right. So Miami 21 and
Well, I understand that.
has it. HEP does not. HEP does not have a section at all.
You're not listening. What I'm saying to you is, I don't remember this argument being made at the last hearing when this was an issue with the Playhouse. And so my point in that is that this is the first time I've heard this argument, which things like this is what leads to different decisions from the same body.
Of course.
So what we'll do is we'll do this 5-minute break to allow you to kind of get your bearings, and then.
Okay. Thank you. I appreciate it.
Thank you.
10 o'clock.
Curfew.
Curfew.
Wonderful. We're back. Right now we have, I know I heard the senator's voice, but I see that we have the vice chairman here and myself. If we have one more commissioner come on, then of course we can make action. And we have that. So, all right, let's we're back here. So,
Yes, sir.
Acknowledge Mr. Greco.
Thank you, Mr. Chair. So to sort of jump in here into the discussion with respect to the Playhouse decision that was alluded to, in that case, the putative they were no interveners; they were appellants. The homeowners appealed, and under Chapter 23, in order to appeal, you have to be an aggrieved party. And what the appellate division did on appeal is say, if you have an appellant that's permitted to appeal as an aggrieved party, but you don't define what aggrieved means, then you have to apply the special injury standard. So what does that mean for this case? In this case, it's different because we have interveners. And under Chapter 23, the chapter of the code that governs historic preservation, there is no provision for intervention. So legally speaking, there is no code authority for intervention in this case. Now, with respect to whether the commission wants to make a policy decision to allow putative interveners to speak or to address issues, that's a policy decision. It is not required. There is no authority for it. But again, the commission, can exercise its discretionary authority and allow them to do that. And what I would say is, for Mr. Cuven, if I'm not aware of any case that gives someone, a homeowner, the right to intervene in an administrative proceeding absent authority in the code. And again, there's no authority in the code for that. So.
Okay, having said that.
Thank you. So,
Mr. Vice Chairman.
Sorry, am I recognized?
Commissioner Reyes. Yes, Mr. Vice Chairman.
Thank you. So then I just need clarity because my original question to the city attorney had to do with whether or not there was precedent of the city commission granting intervener status, hearing the appeal of a historic preservation board decision. And I was incorrectly told that we did on the Playhouse. I'd like to know if there are other examples where the city commission has granted intervener status on a HEP board decision appeal.
I believe we are not aware of any. The Playhouse was not precedent, but as far as any other ones, I am not aware of any. I do not believe any of us here on the attorney side of the dais are aware of any.
Thank you. So if I could just finish my thought from before the recess, it's not expressly allowed, but it's not prohibited either.
Oh my God.
And so the commission has some flexibility here, it sounds like. For me, as I said before, I want to get the best information to make our decision. And B, I want our decision to be binding when it gets to a higher court. I think if we don't grant intervener status to someone who perhaps can demonstrate an injury above and beyond what the general public receives, then our decision could be overturned. However, if we incorrectly, let's say, grant intervener status where we not necessarily should or have to, it shouldn't hurt our decision. But what it does allow us to do is hear all sides of everything. And even though they may be mandatorily granted intervener status on the zoning issue, if and when that comes to us, at that point, they'll never be able to bring up the issues they have on historic preservation, trees, the scenic corridor, etc., on which it seems like they've built a case here to be heard. So based on what I've heard, I would err, if it's an error, on the side of granting intervener status, which should help make our decision more bulletproof as it goes to a higher court if it does. That's just my thought.
Okay, Chris. Well, if the charter it doesn't allow them and doesn't allow them to intervene in status on a headboard decision, I don't think we should start having a precedent, making a precedent here because we thought that we did it before. Although I disagree with Commissioner Russell. When they come for the zoning change, they can state the loss of trees, the loss of canopy, the physical, economic damages that they're going to cause because of whatever the proximity, anything and also the loss of, even the historic, they can bring it up. And what you are assuming is that the appeal is going to pass. That's what you're assuming. And you are talking about it in an assumption, and I'm going to be very honest with you. I'm not going to vote for the appeal, you see? Because I think that they should come back again. That voting against the appeal doesn't preclude them coming back with a better plan and with more, having done a better PR with the neighbors and see if they can come up with a plan that will be palatable with the neighbors, and that's it. You see, and I just want you to know that. You see, but
so you're stating that you're going to vote against the appeal at this point.
Yes, I'm going to vote against the appeal, and I'm going to vote against an intervening status. How do you like that?
But we haven't heard any of the facts yet on the case.
Listen, I think. That is what I've heard. I have met with everybody. Okay, I have met with everybody. I have heard the facts with everybody, and that is was my position from day one. Okay, it was my position with day one. And what we're doing here, and I know you like to do that. You like to go around and around and around and around. I am more pragmatic. I'm more straightforward. Okay, and what I'm saying is the way that I feel. What I informed everybody that came to talk to me, those people against and those people in favor of it, and I have big concerns with traffic, big concerns with what could happen to the neighbors. Okay, but what we're discussing now, you keep on going around it and assuming something that was going to happen. You were basing everything on assumption, and I know you love to do that. But I don't agree with you. I think that in this case, and now that what we are discussing here, it doesn't. I cannot grant. In a clear conscience, I cannot vote for granting an intervening status. That's it. Okay, and I think that let's
Commissioner Reyes, I think since we were talking appeal, intervener, I confused you with the whole intervener appellant thing. I just want to clarify for the record, what you're talking about right now is that you're not granting intervener status. You're going to listen to everything with regard to the appeal.
He said he's going to vote against the appeal.
Right. I'm sorry. I know I confused you. You're talking about intervener status right now.
Well, now, okay.
Wait, press the button.
Now that you make it clear, now that it's clear, I just want everybody to know I'm going to vote against it. Granting an intermediate. That's it.
Okay.
Okay,
and
that's it.
For the appeal, we still have to listen to everything.
Well, let's listen to the appeal. I already know how I'm going to vote.
So does everybody else know how they're going to vote on the intervener status, or do we still have to have more going in circle debate here?
Just need a motion.
I'll make a motion to deny intervener status.
And I second it.
It's been properly moved and seconded that we deny intervener status.
What do you think, Mr. Chairman?
There's 4 of us. That means that if you vote for it, and I vote for it, it dies.
It's true.
So the motion dies. So we just stuck in limbo. So I think you know how that's going to go.
Yeah. All right.
Any further discussion?
No.
Hearing none, all in favor say aye.
Aye.
All against?
No.
Next.
Motion carries.
Okay.
So intervening status is denied.
I wanted to ask one more question. Has anybody met with any of the applicants? Do we want to talk about that?
Plenty.
Plenty. I mean, you name it. You name it.
Okay.
The only person that I have not met is the Pope.
All right. So then
Okay, they have brought everybody. I mean, I lost track of the people that I in favor or against that I come to my house. I mean, I'd have to go back to it. I mean, both the Pope, everybody. You see, I mean, Cardinal Wensky, they yelled for me to bring it up, and he and I, we don't get along too well. So I said, no, please, I don't want to talk to Cardinal Wensky.
Okay, does that, so
But
then,
besides the Cardinal and the Pope,
Mr.
Chairman, Mr. Chairman, how do we proceed now? What's the next step? Do you want to go ahead and hear the argument?
Well, first, in the abundance of caution,
What's your preference, sir?
Jennings disclosures first. So in abundance of caution, because I'm not, I mean, this thing has been around for so long. I understand exactly what Commissioner Reyes is saying. I have had to have met with individuals from both sides regarding this issue. And so I want to make sure I disclose that on the record.
and
And I will do the same thing. I met with individuals on both sides of the issue, so I want to do the Jennings disclosure also.
Ditto. I've been confronted in grocery stores, in my office, on text, on Zoom. So yes, both sides of this issue have given their opinions to me, but it of course does not sway my ability to listen to the facts cleanly now.
okay, perfect. And
The people involved in this debate don't go to my grocery stores, but I've been confronted in the office. My people go to Presidente and Sedano. So,
That's right. They don't go to that.
There's a Whole Foods in Alpharetta.
Absolutely. Whole
get it.
food and everything like that.
don't
neither the
island,
restaurant
no
that I
island.
visited, because my restaurants had El Mago de la Frita and all those places.
Don Tostón, those places.
Don Tostón,
They don't hang there.
Papo Yeguicón.
They don't hang there, right, Commissioner?
No, they don't. They don't.
Mr. If I can, Chairman, one more thing, Mr. Balin and Mr. Wasserman, you're fine. You don't have any issues with the Jennings disclosures at this time. I just want to make sure that's there for the record.
No, I've met with Commissioner Russell. I've met with Commissioner Reyes. Obviously, I've met with the planning director. So those are the folks I've met with in person.
No, not you. I mean, what has been.
Oh.
Our commissioner, you're fine.
Stop snitching.
Right. You're fine with the Jennings disclosures made by the.
Yes, I was just trying to, Vicky, as always, I'm just trying to be transparent as Ethan. No, we have no issue with with their Jennings disclosures. Thank you
so much.
At least that joke was a little bit funny this evening at 11 o'clock.
It was great.
Yeah.
Okay, so I must admit, I didn't, I thought that there probably would have been a granting of the intervener status, not have heard any other argument. Is what I anticipated. And so with that being said, now that we don't have, because I think it was described in the record, they had about 12 witnesses that they wanted to put forth. And so I was anticipating that we will be moving forward with the case in chief at a different date. But now, seeing that we do not have that case in chief, Mr. Wasserman, how much time do you think you need to actually provide an opening statement and kind of present what it is that you're asking of us to do?
We cannot hear you, Mr. Wasserman.
You might have your phone muted.
Is it better now? I need my cell phone released.
Yes, I can hear you now.
You can hear me?
Yes.
Okay, we need about 25 minutes to work through our presentation.
All right. Let's go.
I'm sorry?
Let's go.
Okay. Bear with me 1 second. And do we have access to share screen at this time?
Yes.
Okay. Okay, good evening. Commission, again, for the record, Ethan Wasserman and Ryan Bayline with Greenberg Charlotte, 333 Southeast 2nd Avenue here on behalf of the appellant. There's a large group with us tonight. We have Richard Heisenbottle, our project architect, Elizabeth Van de Leeuwen, and Andy Witkin, our landscape consultant, Bob Carr, our archaeologist, Olin Kalkis, our head of school, and my colleagues Ryan Bayline and Marissa Newfield. We are here today on appeal of two HEP decisions relating to our application for historic and environmental approval of our development plans for Villa Woodbine and the surrounding properties. We will present evidence to you all today which confirms that the HEP did not base their decision on substantial competent evidence, and we are seeking your approval today. By way of quick background, we went to HEP in September of 2019. At that hearing, we made a substantial presentation explaining how our application preserving the historic structure and the new construction did not only not have an adverse effect on the historic components of the property, but was completely in line with the special guidelines imposed by the property's historic designation report. We also provided significant testimony, excuse me, showing how the plans preserve the natural environmental features such as the rock bluff, continued the scenic transportation corridor on Bayshore, kept the major trees on site while installing significantly more native and healthy trees than exist on site today. All in attendance had an opportunity to be heard. There was a significant amount of dialogue and requests for information from our team. The item was ultimately directed for a continuance to address what the board felt were a narrow 3 to 4 issues that they wanted additional clarity on. And specifically, those items were the landscape drawings, landscape section drawings, preservation efforts, what we did to preserve tree 460, which we'll talk about, the rock bluff platform details, and the rock wall section details scattered throughout the site. We did just that. We supplemented our application to provide additional data at the board's request and re-presented in December of 2019. At the end of the hearing in December, the board seemed very comfortable with our application and proceeded to a vote. Unfortunately, both applications obtained a split decision, 4-4, which by code is deemed a denial unique to the HEP decisions. To this day, we do not know, and quite frankly, I don't believe your professional staff understands why specifically the board denied the application, as there was no indication as to how our project did not comply with the clear code criteria for approval. I will mention that there was significant discussion of whether the exception application governing the school use and the associated traffic issues governing that use could be a factor in the decision, as well as the procedure of whether the exception should come before the HEP decision. The city made it explicitly clear to the HEP board that those issues are not part of this application and should not be a factor in their decision-making process, as those issues are clearly outside the bounds of this application and do not speak to the merits or criteria of the application. To be clear, the HEP and this commission is bound by the code and must limit its review to the application before it, the code requirements contained in Chapter 23 and Chapter 17. We believe that decision was made in error and not based on substantial competent evidence. The transcript of the hearing is, of course, part of the record before you, and I believe everybody is familiar with this project at this point, given the amount of outreach, but I will try to give some background before I turn it over to the rest of my team. Specifically, our application covers a few distinct areas that are worth mentioning individually. First and foremost, the critical piece of all of this is the crown jewel of Villa Woodbine. That's gotten lost in almost all of the discussions and quite frankly was very much ignored at the HEP level. And the reason for that is simple, is because we're doing such a good job preserving it that no one wants to talk about it. Villa Woodbine is the true reason we're here. There are other incredibly important issues, but the centerpiece of this entire discussion is the Woodbine structure, and you will hear about our restoration and improvement efforts in a minute. Notably, HEP had no objection to the renovations and improvements to the structure. To the contrary, there was positive discussion about the design and compatibility of the 2 new structures located in the rear and side of the property, located exactly where the designation report states new development shall occur, and I'll mention that a little bit later. You will hear about our effort to preserve the rock wall formation throughout the site and how the formation of those walls on the property dictates the shape and form of the various improvements located on the property. You'll hear from our archaeologists about the rock bluff formation on a specific portion of the property, how the exposed bluff in front of the existing home to our north and the existing bluff in front of the home to our north and the bluff in front of Villa Woodbine will remain exactly as they exist today, whereas the bluff that's currently invisible, it's not a significant formation, and it's not even a part of the historic property, will be exposed by my client and open up as part of a viewing platform for our use going forward. You will hear today how we are removing prohibited tree species. This is a requirement by the city's code, and our landscape consultants can address that for you in more detail. When it comes to trees and tree canopy, we provided evidence and testimony that there will be more trees than exist today, more of the non-prohibited trees, more native species than exist today, and more canopy that exists today, assuming natural and maintained growth. It is important to understand the tree dialogue in the context of native healthy trees versus prohibited, damaged, dead, and non-native plant species. So that's a high-level review of the application and what we're going to cover to frame the discussion. But for the record, I want to provide some technical guidance. There are two separate applications that are before you with two different code sections governing these applications. There's Chapter 23-6.2H, that relates to historic preservation. There's 17-36, which relates to the environmental preservation and the scenic corridor. These citations are, of course, part of the record analysis, but we have also submitted into the record copies of these code sections. Now, all of these issues are really intertwined, and so we're happy to make a unified presentation to all of you as we did at the lower level at HEP, but I do want to take the time to explain for your benefit what it is we're talking about and where on the property we're talking about it. So if I can, bear with me, I would like to share my screen for a second. I hope you are all able to see my PDF of three different outlines of the property. So you have the historic property here, and this is taken from the city's Miami 21 website. And you can see it's a little bit off, but that's just how it's copied from the city's GIS map. The historic property is basically this narrow strip going down to the property. It does not include these two single-family homes on this side of the property. It does not include the outer bounds, and it certainly does not include this area right here, which just has a single tree cluster right in this location. And this is where one of the rock bluffs that we will be talking about. The second image that you have is the Environmental Preservation District. This is EP60. This relates to trees and relates to the rock bluff formation. You can see that it doesn't extend to the rear of the property, but it basically covers our neighbors in this area. The Scenic Transportation Corridor is, of course, right here on Bayshore Drive. So you can see there are a lot of things to consider, and the shape and form of the application that are before you are very specific, and I want to explain why. According to Chapter 23 in the city code, the Bible, so to speak, of this application is the property's historic designation report. In the historic designation report, it addresses what is historic and what is not, and where future development should occur. This guidance was not created because of our application. This guidance was created several decades ago. So this box that I just put up identifies very explicitly and succinctly what the designation of this property was meant to do. And I will read it directly from the conservation objections. Every attempt should be made to preserve Villa Woodbine. That's exactly what we're doing. It's unobstructed views to South Bayshore Drive. That is exactly what we're doing. It's Limestone Bluff. That is what we are doing. Because again, remember, the designation report covers the center piece of the property. The major trees on site, it doesn't say all trees on site. It says major trees on site, and that's what we're doing, while allowing sensitive development at the rear of the property and on adjoining lots. That is exactly what we're doing. We took this very literally and applied it to our site planning. So before I close or turn it over to my design team, I would like to quickly mention this application has done some very unique things. Let me take you off shared screen. I apologize. When we originally designed the project, one of our neighbors asked us to move the building over. We did that in our submittal. But when we moved the building over, city environmental staff became concerned with the impact that would have on one of the trees, tree 460 specifically. So we went out and did a 3D laser scan. I'm not aware of anybody else doing such a test. I don't think staff is aware of anybody taking the time or money to do that. Once we understood the root system of the tree and we were able to superimpose that onto our plan, which I think you'll see later in the presentation, and make staff comfortable with the location of our building, staff was supportive of the design and its impact on this tree. I tell you this so you are aware of the length my client went to design this property. I will close with an acknowledgement that staff is fully in support of both applications, as evidenced in their staff reports, and we agree with all staff conditions as originally proposed to the HEP board. We appreciate the time staff took to work with us on these applications over many months to make sure they were the correct shape and form. And again, what I mean by that is you have major trees on site, you've got a rock bluff, you've got a scenic transportation corridor, and you've got rock walls scattered throughout the site. Our two buildings, which are nowhere near as large as they could be, they're not as large as the code allows, takes all of this into account while keeping a historically sensitive design. That is what you have before you. Staff review and this commission is, of course, limited to the application before you and the code for these specific applications. I'm happy to talk further about community outreach that we did very early on in the process, Carrollton's strong stewardship of historic and environmentally important properties. But in the interest of time, I'll turn it over to our design professionals. Rich?
Thank you, Ethan. A pleasure, commissioners, to be with you this evening. For the record, my name is Richard Heisenbottle, FAIA, and I'm president of RJ Heisenbottle Architects with offices at 2199 Ponce Leon Boulevard in Coral Gables. And I must say that I am very honored to be the architect and preservation architect for Villa Woodbine. Just as in the past, RJ Heisenbottle Architects has received national acclaim for the restoration and design of historic schools. We should also recognize that the Carrollton School has proven to be an extremely excellent steward of historic schools, El Jardín. You know, in fact, I would venture to say that no one takes better care of their historic buildings, of their historic landscapes, and their environmentally sensitive property than Carrollton. The gloom and doom predictions that we've heard about this property and what it will do to the surrounding properties are simply false. Contrary to what you have heard, the property is not in very good condition today. So let me take you on a walk through what we propose to do and bring you up to speed as to what the existing conditions really are. What you're looking at on my screen right now, and I excuse the fact that it's not a full screen at the moment, is the original Villa Woodbine, designed by the famous Walter DeGarmo, one of the fathers of Mediterranean architecture in South Florida, along with Keenan and Elliott. The building was built in 1931. We all know where the site is. We've all driven past it hundreds of times. It's across the street from Kennedy Park. And the scope of work, what are we really doing here? We're doing selective non-historic demolition. We're doing new site work, including site grading and new parking. We're restoring and rehabilitating Villa Woodbine. That's the center of the attractions here, and that's the reason for this certificate of appropriateness. We're doing miscellaneous repairs to the adjacent residence, and we're constructing 3 new buildings and a pool. One of those buildings is an extremely small storage building. So what do we have to work with? How do we begin this project? How do we make the design decisions that that needed to be made to do this project?
Rich, I apologize. I just want to let you know, maybe it's me. I don't think you're sharing your screen. I can't see it.
No.
Maybe it's my tech.
We can't see.
Thanks
Yeah, we
for telling me,
can't
guys,
see
before
it
we
either.
finish.
I was
Bear
going
with
to
me one
interrupt
second. I'll take care of that.
Thanks. I thought it was my technological ignorance, but thank you. Sorry to interrupt, Rich.
No, please. I'm really glad you did. I just hard to imagine that.
So go back if we can go back.
I apologize, commissioners. That should get us a good laugh at this hour. So
Can you go back to where you started? Just do it quicker.
I'll do it quicker. Yes, sir.
Okay.
Got to press those buttons, Richard. Okay. So apart from the preamble to this, I do want to show you, I want to make sure that everyone really understands that this is one of Walter DeGarmo's many Mediterranean masterpieces built in 1931. And as I said a moment ago, Walter DeGarmo, along with folks like Keenan and Elliott, who we all know, were the fathers of Mediterranean architecture in Miami. Let's skip along here just a little bit to show you the kind of things that we have to remove from this site. Now, this site is actually very sloppy. It's sloppily taken care of today. We have at the rear of the site, and I think you can see my cursor over there, we have 2 existing residences at the rear that are in varying states of disrepair. So we're going to remove those existing residences. We have a parking lot that is not really a parking lot at all. It's not striped. It's not lit. It does everything illegally. But we're going to be tearing that all up and removing that existing parking lot. I'm going to remove an old storage building over here as well, all to make way for the new in this particular case. And in case anyone has missed it, Where is that historic building? Well, it is Villa Woodbine itself is right here with its central courtyard in the middle. So we have in fact three new buildings on site. Building number 1, building number 2, and behind the caretaker's house, a small building number 3. So let's take a moment and enter the site through Tigertail. There's a turn lane along Tigertail, and one goes in and driving past building number 1. So what does the Tigertail entrance to this property look like today? Well, it's got a wonderful coral rock wall, but other than that, the property is actually in an interesting state of disrepair. And so one of the things that we tried to do is to make sure that along Tigertail, we maintain the tree canopy that you see outlined on this existing condition photograph, and that we develop a new entrance along Tigertail, a new enhanced entrance along Tigertail that will enhance the value of the adjoining property, that will in fact clean up the sloppiness and level of disrepair that is there today. So this rendering that you're seeing is a rendering of our proposed new entrance along Tigertail with additions to the coral rock wall and maintenance of the tree canopy. In fact, from this rendering, I've actually removed some of the tree canopy so you could begin to see the building. The building along Tigertail is in fact 2 sections of building that are actually one story. So the areas closest to the street on Tigertail are 1 story high with outdoor teaching facilities on the 2nd floor. And this is how we propose to enhance the entrance to the Woodbine from Tigertail in much the same way as we have those wonderful entrances at El Jardín. The building itself, the building number 1 itself, is actually a takeoff on Mediterranean design. It is done in the Mediterranean style. The next slide that you're going to see shows a building that is very, very similar. Whoops. There it is. That is very, very similar to the kind of thing that you would have seen by Keenel and Elliott. Buildings are broken down into pieces. There are lots of use of the same sort of ornamentation or archways. And one of the things that we've kind of added to this, because we have so many coral rock walls on the site, we maintain nearly every coral rock wall that is out there. I'll show you more of that later on, but if you look carefully at the base of this building, there's a wonderful coral rock wall there. Let's move now from that building as we've driven into the property and driven by it. And about 40 feet away from that building, actually a little more than 40 feet away from that building, and across an entry drive, is in fact the landmark Villa Woodbine. And this is exactly what it looks like today with its Mediterranean revival architecture. As I'm sure you've attended events there over the years, but this is in fact that main entrance. Usually it's obscured by someone's tent, but this is looking into its central courtyard. We'll be in the central courtyard in just a second. This is that central courtyard. And fountain with its quality detailing and craftsmanship, the iron grill work, the decorative floor tiles, the arched openings, all of which makes it so very, very special. And it is our job, of course, to restore the building because, in fact, it is not in quite the kind of condition that we would expect a building of this nature to be in today. So as we looked at this, we got into the details of all the things that needed to be restored there, and this is one of those very special trees in the motor court we will be taking extra good care of here and assuring a good long life. I mentioned before we get into some of the detailed drawings of the COA for the restoration of Woodbine, we mentioned the coral rock walls and coral rock steps and the bluff. Well, this is what the bluff in front of Villa Woodbine actually looks like, along with coral rock walls that have been and stairs that have been carved into it over the years. This is the kind of condition of the coral rock walls that you would see around the rest of the property. This, we think, will make a wonderful fountain once again as we restore it, and it looks like it would make a perfect place for a piece of statuary of the Blessed Virgin. And so now we need to move on to what are we actually doing to Villa Woodbine as part of this certificate of appropriateness. This is what it will look like when it is restored, but I want you to get a feel for the kinds of things that we're doing. First of all, this is the plan for Villa Woodbine. It's a modest courtyard structure, and our reuse of this structure is done in a very, very sensitive way. You know, rather than finding uses that are inappropriate to the building, we have come up with uses that are very appropriate to the building. A chapel goes where the living room was, a conference room, a teacher's lounge. You know, those are all perfect adaptive reuses for a facility such as this. Executive offices, administrative offices. And in fact, we also go so far as to make this rather interesting two-story building handicapped accessible without ever poking our heads through the roof of the of the building. What you're looking at now are the detailed drawings for our COA. If you look closely, you see the existing conditions, and I want to just give you an idea of the kind of things that we have to fix. So I'm going to blow this up a little bit more than we might normally do. What you'd find if we walked out there together, we'd find that there's conduits all over this building. There are exhaust fans from kitchens that, you know, from a more industrial kitchens that don't belong on a building like this. There are air conditioning units being poked through windows. There are wood windows that were wood windows that are missing. And all of those sorts of things, all of that, those elements that don't belong in a mansion of this nature are here to be restored and accurately replicated through the originals and replaced going forward. Literally from the roof down to the electrical systems and the mechanical systems, all of which will be hidden. We expect nothing short of a sterling restoration in complete compliance with the Secretary of the Interior's standards. So as we move from Villa Woodbine itself, I think you can all see where that is at the center of the property here with its central courtyard. We wanted to show you building number, what we call building number 2. Which is again set some 35 feet away from Villa Woodbine and across the road. And as Ethan was quoting from the original historic designation report, one of the things that I like to point out about why we chose to build in these locations is exactly what I was alluding to earlier when we got kind of confused up there with the site plan. This is the perfect location for building number 2 because there's nothing in its way. There are no trees to take down. This is a great location for siting a building. This is that other adjoining piece of property that Ethan referred to earlier. And I forgot to mention, which I should not have, why did we put building number 1 where it is over here? Because that's where we're tearing down these 2 dilapidated single-family homes. That's where we have parking areas today, and that's where we have the least impact on the physical site. And from the very, very beginning, It has been our goal and the school's goal to do to have the least impact on this site. So back to building number 2 for a moment, and that kind of vacant parcel of land, that grass area that we're placing it on. What you see, if you could see closely enough at this, and I'm not so sure that you can this evening, you'd see that our Coral Rock Bluff runs across the site, and that we have an outdoor deck that bridges over top of this Coral Rock Bluff. Now I'm going to show you in a few minutes what that Coral Rock Bluff looks like. It's just a meandering little line. It's not, but it also has a specimen tree growing out of it. So rather than damage that tree or rather than damage that bluff, it has been our position that we need to bridge that bluff. We need to go ahead and cantilever over the bluff. We need to create a nice facade with arched entryways here to receive folks in building number 2, and we need to celebrate the bluff by creating an area, an observation area, which is this area that you actually see in white. This is an outdoor deck that bridges over the bluff and becomes a viewing deck, a play deck, and a viewing deck for the pool, which is just down a set of stairways. Just to clarify a few things that will be of interest. Every one of these little red lines that we put on here, these dashed lines that I do hope you can see, every one of those is a coral rock wall that is to be preserved. We're going to let our landscape architect talk about our trees and tree canopy in a few minutes, but the new trees are the ones that you see over here in the light color green, and the existing major tree canopy is what's in the dark color green. And in addition, we're doing nothing whatsoever.
I want to interrupt you 1 second. I just want everyone to realize that the 25 minutes has expired, so we'll provide an additional 10 minutes. I just want to make you all clear of the limitations that you placed upon yourselves.
Thank you, Mr. Chairman. We'll wrap this up pretty quickly.
We'll transition to Bob right now. Mr. Chairman, Mr. Chairman, thank you so much. I appreciate your time and your leniency. We just have a couple other folks that want to jump in, only because of the technicalities of the application with the landscaping and DVH and what have you. Rich, please just, you wrap up as you see fit, and we'll go from there.
Yeah, I'm going to, what we're going to do right now is to put this photograph of the bluff up on the screen. It is more like a grassy knoll, but we would like our archaeologist, Bob Carr, who's been with us in the very, very beginning of this project, to talk about the bluff and talk about how he has recommended we deal with the bluff, and quite frankly, that's exactly how we dealt with it. Bob, can you step in here? Are you ready to speak? Did I lose you, Bob?
I know that Bob was on the list of the folks that were going to be promoted.
Bob, did you raise your hand for staff to see you? And unmute your line.
Robert Carr, is he promoted?
It comes up under field notebook. You can see him, he raised his hand. If we could stop the clock for a minute, Mr.
Can you hear me?
I apologize.
Yes, there you go, Bob.
All right, good.
There you go.
So
I'm going to mute, which I assume everyone will be thankful for.
The Silver Bluff Formation, this limestone formation traverses the parcel, as Richard indicated. But what's important to note is that on the southern portion of the property, it's very much obscured by soils and sediment that actually had been pushed over the bluff at a previous clearing and development activities. But nonetheless, the ridge, the bluff, is a very important natural and cultural feature. So it's our objective and goal to protect it and to actually, at least in one location, uncover it so it can be exposed and become an educational opportunity in terms of being able to see and experience the bluff. And as Richard explained, crossing over the bluff without impacting it is in line and consistent with the City of Miami's historic preservation guidelines, which is to maintain and protect the bluff wherever possible. And though this is not the best example of a bluff, this is certainly one that is worthy of preservation, and that's our intent. I'll further be involved with this project in terms of monitoring all construction that is anywhere near the bluff, and also conducting an archaeological assessment of the property as part of the overall protection of the property.
Every time we dig, Bob will have checked out that area beforehand to make sure that we're not uncovering or damaging anything of historical significance. And to just move a little bit further towards the road before I turn this over to our landscape architect, this is the west lot. The bluff is up at the top of this photograph that you see. And it became an excellent area to place the pool. Why? Because once again, it's an area where we can do no damage. It's an area where we're not tearing out any significant trees, any trees whatsoever in that particular case. So it became the perfect third location for one of the major building elements. And as we talked about,
and Rich, I think Rich, I think this is a good transition, since you said you just mentioned removing no trees whatsoever, for Andy and Elizabeth to jump in on the landscaping aspects of this, because as you know, we're here about the preservation that you are promoting and that you are quarterbacking, and the trees and the DBH and the scenic corridors that they're handling this evening. So I think the Whitkin folks have been promoted, if that's the right word, and I'd love for them to jump in and explain exactly what we're doing, and then to turn it back over to you, Rich.
Thank you, Ryan. Thank you, Rich. I'm gonna share my screen now, if that's okay.
Please do.
Can you please stop sharing? Yeah, thank you. Good evening, everyone. For the record, my name is Elizabeth van Dilleveen. I'm a project manager and landscape designer at Whitkin Holtz Design Group, 307 South 21st Avenue, Hollywood, Florida, 33020. I know that everyone is tired, and we just ask for 5 minutes of your time for this very, very delicate and important matter, which is the trees of Villa Woodbine. We would like to start our presentation, me and my principal, Andy Whitkin, by highlighting the three most important responsibilities and goals that we have in this project, and that is in regards to the trees. Our goals are to preserve as many trees as possible, like the one you're seeing on your screen, which is a picture we took from on the site. We want to enhance all the natural landscape features within the site, and we need to make sure that we integrate any new proposed canopy with new healthy native trees that will thrive and will complement the surrounding community. With the three goals in sight, we would like to share with you our tree disposition plan. We began this process by quickly doing an analyzed study of a survey of the property, showing all of the trees that are involved, including neighboring trees. We have highlighted everything in color so that it's easy for everybody to understand. Trees that are highlighted in green are trees that are going to be protected, and they're going to remain as part of the final project. Trees that you see here in orange are all invasive and prohibited. And as you see, they're spreading quickly through the site, and they need to be removed per code. Trees that are in purple are fruit trees. And we would like to mention that out of all the 26 trees that are on site that are fruit trees, only 2 of them are in good condition. Every single one of them is in bad and poor condition, therefore requested to be removed. There's also trees that are going to be relocated on site, and these are marked in the blue circles that you see around the site. They're going to be kept but placed in a different location within the site. And trees in red are trees that are going to be removed because they are in poor or bad condition, and some of them are in conflict with the proposed structure. As you can see, we have developed a preservation canopy diagram to better understand and to show you and for us to understand as landscape architects what we're doing with this site. In terms of canopy preservation, we are keeping every single specimen tree that is along Bayshore Drive. We're removing every prohibited species that is close to tiger tail and some of the trees that are in really bad condition, which gives us our second diagram showing what it would look like once we removed. Our third diagram shows us what we need to do to make sure that we're integrating, enhancing, and making the property what it needs to be and where it could be. So all the trees that are highlighted in dark green are proposed, and trees that are in the light green are remaining and to be protected. We're just going to run very quickly through some items that have been mentioned before, but I think it's important to understand that we have gone above and beyond to preserve large specimen trees with the help of staff, with the help of the design team, with the help of the client. This tree is a picture of the tree number 460, which is a strangler fig, a specimen tree near the tiger tail area, which is a almost 50 to 60 foot diameter in canopy, which is going to be kept. And a lot of design elements were implemented to make sure that that tree would stay on site. The same thing for a specimen tree, native also, number 415, it's a mahogany tree. There's going to be a special treatment for driveways to make sure that this stays at the center of the property without any complications for its thriving. Also, live oak specimen tree, native tree, number 296 is a live oak that is not in the best condition, but we're doing everything that we can to bring it back up to its natural condition and its thriving condition, and working with the architects to make sure that it's part of the project, inclusive of educational purposes, and that it's included into the overall design. Some of the other trees that we like to mention are specimen trees like this tree number 223. It's a huge tree, but it's not in the greatest condition. Our goal is to make sure that we help it by removing all the coverage, all the vine coverage, and make sure that it thrives, and believe that with the team that we have put together, we can do so. Other pictures close to Bayshore Drive show us these beautiful specimen trees that are in need of our attention to make sure that they are what everybody thinks it is. They need to be taken care of. They're not in the best condition, but we're not removing these. We are keeping these, and we are helping them come back to its natural environment. This is an elevation through Bayshore Drive. We wanted to make sure that people understand that all of the canopy highlighted in this diagram is being kept. The streetscape along Bayshore Drive is going to be enhanced. It's going to add street trees per the street tree requirements. Is going to completely beautify and add to the scenic route of Bayshore Drive. None of this is going to be removed. It's going to make sure that our project is going to preserve and enhance. The same thing as Rich was mentioning in the beginning, along Tiger Tail. The only thing we're removing from Tiger Tail is, by code, all of the invasive trees that are running along the coral wall and preventing new growth and preventing natural and native species to be thriving in this area. We're keeping, this is the canopy of that large oak, the large specimen tree 460 that we were talking about earlier. It's important for everybody to understand that not all trees are created equal, and they are invasive and they spread very quickly. And we would like to, as landscape architects and designers, make sure that we are doing the right thing for this project, the best thing that we can do with the trees that are existing and the trees that are being proposed. A lot of the trees that are on site that are being documented may seem really big on numbers on paper, but this is the reality of what a lot of those trees are looking like in this property. And it is our job and our duty to make sure that we save these trees and we bring them back up to what they need to be. So how do we do that? We do that by introducing native species to the area. These are some of the pictures of the trees that we are bringing back. Trees that are very scarce around the city: slash pines, gumbo limbos which are great for this type of environment. Pigeon plums, which are desirable, they're beautiful to look at, and they enhance the natural environments. Same thing with understory trees, such as the ones like you're seeing on the screen right now. This is a proposed landscape plan. It is very detailed. It clearly shows all the trees that we're preserving, especially on that historic preservation area along Bayshore Drive. The heavy buffer that we're doing all around the site to prevent any, to integrate with the neighboring properties, to integrate with both Tiger Tail Avenue and Bayshore Drive. There's around 212 species that are going to be introduced to integrate and enhance this property. And we would like to end with a rendering of what this is, of what the final product would look like. We'd just like to mention also that for the existing trees, there's going to be 46 trees that are going to be preserved, the majority of them being specimen trees. There's going to be 197 trees put in this site when we started with 164. This truly tells a story of how we work together as a team with staff to keep the majority of the specimen trees on site. We design a landscape that adds more native trees and healthy trees into the property. And we know that with the proper maintenance and proper care, this site will continue to grow and thrive for many years to come. I know this was short. Thank you so much for your time.
Elizabeth, thank you. Thank you so much for your thorough, detailed plan, and Rich as well. And if I could, Chairman Hardiman, just for about 90 seconds more, is that okay, or am I done for this evening?
No, I'll give you the 90 minutes that you request, but I will let you know. I mean, we know the 10 minutes expired.
No, 90 seconds. 90 seconds. Not 9 minutes. I apologize.
Just before midnight, though, if we push a little bit longer, the city clerk will need a little break to make some adjustments. But you're recognized, Mr. Bailey.
Thank you so much. So 90 seconds, and you can time me and cut me off, and just like my wife and children do. So we know you've had a very long day. We've had a couple HEP board hearings. We've been before you, and we requested a deferral, and then we requested a deferral last month. And I was up at 6:15 this morning and drinking coffee and watching TV and reading the recommendations of your professional staff. And wasn't really focused on the fact we'd be here till midnight tonight, but was certainly prepared because this is important. And what's important is the preservation of these assets, the trees, what Rich has done, what Witkin has done, what Andy and Elizabeth have done. And we've heard a lot today. We've heard a lot of comments in favor. We've heard a lot of comments about other issues in the future. And I hate to go a little bit off topic for a few minutes, but my grandparents grew up in Boston, and I go up and see the baseball games, and the Red Sox were always losers for many, many years. And I feel that from your staff's perspective, from Francisco's perspective, from Warren's perspective, we have a strong recommendation this evening, 2 recommendations this evening of your support. I know Commissioner Reyes, you earlier, you voiced your concerns on our appeal. Commissioner Diaz de la Portilla, I have no idea what you're thinking. You and I have met once or twice, but I'm not sure. Commissioner Russell, I've spoken to a bunch of times. Commissioner Hardiman, I respect you, and I've spoken to you. Your staff is supporting us this evening. And to go back to my Boston Red Sox, we didn't win the World Series for a bunch of years. And this is the first step. I'm on home plate tonight. Carrollton's on home plate tonight. And we have a runner on first. And we're down by 2 runs. And we're just trying to get to the next step. We know that we have a lot of stuff to do to collaborate with our neighbors, to figure out what the right thing to do for the community, even though we have approved traffic studies and what have you, and planning's behind us. I'm hoping we can get your support this evening for the preservation and the trees. There's a lot of noise about traffic and other stuff that I believe in my heart of heart. I've worked with the Carrollton folks for over 15 years. We've built buildings on other campuses. We've encountered opposition from neighbors and adjacent property owners, and it's always worked out well. And if I can go back, I think today is Thursday, so the last time I spoke to Commissioner Russell was on Tuesday, and I told him, Commissioner, I can think of 15 to 20, and Commissioner, quote me if I'm wrong, I can think of a bunch of things we can do to work with the community in the future on this project to get it to where it's a collaborative and a truly harmonious situation. But tonight we're here about the preservation that Rich Heisenbottle and that Andy Witkin and our team has done. And all that I can ask is that you do two things, just two. Number one, it's Thursday night, almost Friday morning. So get me to Monday morning where I can start that dialogue again with the community. And number two, if Commissioner Reyes and Commissioner Russell and Commissioner Diaz de la Portilla and Commissioner Hardeman, if we're trying to figure out something in the future on our next application, and you all are being reasonable, and Carrollton, who has a long track record of being tremendous, if they're pushing back, guess what? I'll step aside. I'll resign. Let someone else represent them. I'm just asking you to help us get to second base tonight. We have a lot of work to do. And in my heart of hearts, and I have never, ever gone this distance for a client, but I know these people. I believe in them. And by the way, I happen to be a pretty observant Jewish guy. I'm not Catholic, but I respect the hell out of them. All I'm asking you to do is to vote on the merits of the application tonight. It may be appealed. It may not be. But guess what? Starting Monday morning, I will be the guy that calls Lowell Cooven and the attorneys for all of the folks in the Grove to try and work out some type of cooperative agreement. But tonight we're here on preservation, which Rich is amazing, and his team, and trees. And I'll answer, and we'll answer any questions you have, but all we're asking tonight is to get us to the next step.
Thank you very much.
Thank you very much.
I know you need you need your minute or so.
Yes, sir, Chair. Go ahead. So give us about 2 minutes, sir.
Yes, sir.
Yeah. It's close.
By the way, I said I was done, but good morning, everyone. It's 12:01.
About 60 more seconds, Chair. Just about there.
Todd, did you bring pastelitos? Pastelitos and café con leche. Were you a Yankee fan?
Sorry, sir?
I thought you were a Yankee fan. This gentleman is a Red Sox fan.
No, I'm more of a Orioles.
Orioles?
Yeah, DC. Not too much to brag about there.
Yeah.
I was a Red Sox fan growing up because we always rooted for the underdog in my house.
Yes,
and,
I mean,
and when
they had a bunch of years that they had bad luck. I mean, there was
Commissioner, I can tell you, I was at game one of the series in 1986 when the Red Sox played the Mets. And we should have won, but we lost. And then they had the Mookie Wilson thing in Game 6.
Wilson, that role.
Yeah.
That's right. Yeah,
My family, we always for many years, and still to the day, we.
No, but you were snake.
My grandparents.
I thought you were.
My grandparents were from Eastern Europe, and we always rooted for the underdog.
Yeah, so
that was our.
So do I.
and they settled in Boston, so that's what happened. They rooted for the underdog for so many years.
I don't have anything against you or the Boston Red Sox, but
no.
You see, but you might find some Yankee fans that might not like it, you know. But
all right, everyone, we're back on the record.
Okay.
Okay. So, does that conclude your presentation?
It does, and we'll be happy to answer any questions you have. Regarding the staff recommendations and anything that for example, that you may have heard earlier today, that we're asking for 500 students. We're not. That we're asking in the future to increase grade levels. We're not. But again, we're here this evening. I know it's very, very late, and I appreciate you've indulged us. We're here on the preservation that Rich and his team have done, and the trees that the Whitkin-Holtz folks have done. So the answer, I guess that's a lawyerly, long-winded way of answering, Commissioner, Chairman. No, we don't have anything else.
Okay. Just so a response from preservation, Mr. Adams. I had an opportunity to read the recommendation from the preservation office, but can you explain it to us on the record, please?
Certainly. I'm Warren Adams, preservation officer. The proposed development follows the requirements of the historic designation report. The designation report recommends that any new development be to the rear of the existing historic building and the sides of the historic building, and that is what they've done. They have not asked for any waivers for any requirements. The proposed development is within the zoning requirements. The architectural style is appropriate for the existing building. I do not believe that the new school to the rear of the building is going to dominate the historic structure. And really, the new auditorium and the swimming pool in the lot to the left really falls outside Chapter 23, because that is not part of the historically designated site. The whole site, however, does fall under the purview of Chapter 17, and Chapter 17 basically holds the requirements for protection of the bluff, protection of the coral rock walls, protection of the tree canopy. We followed the advice from Environmental Resources regarding the proposal for the trees, and we followed the the proposal to actually build the viewing deck over the bluff actually does protect the bluff. So from our point of view, the proposed development did meet the requirements of the designation report, the historically designated area, the archaeological requirements, and the requirements of Chapter 17. And as was mentioned, there are certain conditions that came with the recommendations of staff, but they were not read into the record at the time because the vote was the request was actually denied. But there are lists of conditions that we would want to see met should it be granted.
And that the list of conditions that you will want granted if this appeal was granted, that's included in the record?
They are included in the staff analyses, which are part of the record.
Thank you, sir. And here we are, gentlemen.
Hello?
Ready for discussion? Questions?
Discussion?
Yes, Mr. Chairman.
Thank
you very much. And while we have Warren, I guess I'll start with the bluff. If Warren is still on, please. My question is with regard to Chapter 17, protection of the scenic corridor. If we're to be protecting the bluff and visual access to the bluff, does not a pool covering that bluff affect its visibility from the scenic corridor, as if you're driving down Bayshore looking at the bluff? Is it enough for them to place a deck covering over that bluff with a viewing angle from above, so that only the people that are on the property, the students, for example, are able to look down into a hole and see the bluff? Or is the protection of the bluff and the visibility of the bluff meant to be from the scenic corridor? I'm looking for some interpretation here, because it seems like a pretty narrow definition of protecting the bluff and viewing the bluff by covering it with a deck and putting a hole down into it. Could I get a little help there?
I believe that the designation report states that the bluff should be protected. Certainly in front of the historic building, the bluff will still be viewable. And I think you heard Bob Carr, the archaeologist, suggest that the bluff at where the pool is proposed is actually being covered up with debris from possibly prior buildings on the site. So the bluff is still going to be visible in front of the historic building, although I do concede it will not be visible where the proposed pool and deck is meant to be going. It will not be visible from the right of way at that point.
My other question on the bluff is with regard to whether or not, let's say it has been covered over by debris, is there a responsibility to clear that debris so the bluff is visible? And does it matter whether or not the rock of the bluff is visible, or if the mound itself, the geographic structure of the bluff is what's visible? Because right now in the area where the pool is, I don't believe we see the exposed rock bluff, but we see the grassy knoll, as Mr. Heisenbottle called it. That is the bluff. So is that meant to be protected? And I guess your interpretation of protection is that it's not being demolished; it's being encased by the deck and the pool, but you can see it from above. Can you?
My interpretation is that it does not appear to be being damaged by the proposed new development, so it technically is being protected. One possibility would be to remove the debris from it, but obviously the swimming pool and the deck would still obscure its view from Bayshore at that point.
Got it. So I think it's just about an interpretation of the words protection of the bluff and viewing of the viewing corridor. So I understand. Thank you. I appreciate that one. Regarding the preservation of the actual Woodbine Villa structure itself, I have a lot of respect for what Mr. Heisenbottle has done. And I do recognize that it is not in the greatest of condition. I've never been in there, but the photos I've seen and the condition I've read express that. So, I certainly have a lot of respect for what Carrollton has done with El Jardín, and certainly what Mr. Heisenbottle has proposed here for the historic structure itself. I do recognize also that we are not working with chapter 23 outside of that center line quarter of the property. Those two wings of the property actually are not in the historic preservation section, but are protected by chapter 17. And that's why I had those questions about the bluff. The other main issue we're dealing with today is trees. And so I have some questions about trees, because the first question is, who will speak for the trees? I mean, if not us, and obviously the neighbors don't have intervener status, and I'm sure they would have challenged a lot of that based on what they've lobbied me on. I've done my own analysis of just looking at the chart of tree mitigation, more so that than the chart of landscaping plan. That plan is it looks very lush and very green, the landscaping plan, but there are trees on there right now. And I heard it was very rapid pace, but I heard all of the statistics of how what's going to happen with the existing trees that are there now. I could use a little help either from Quatisha in our department or from the presenter from the appellant side with regard to the tree mitigation plan to answer a couple questions here. The first
Elizabeth, can you jump in just because you're so close, and to the extent Quatisha has some questions, let her. But since we're the ones that are proposing this, if you could take the lead with Commissioner Russell, that would be great. And if he has further questions, then Quatisha can jump in.
Absolutely.
Thank you. So I understand with regard to prohibited trees, they don't present a concern to me. I know that over 50 of them are being removed, and that's to be expected with any development that would happen there. But the trees that are being removed, not relocated or replaced, relocated or preserved, but actually just being removed, it's 64 trees is my understanding. And that's a lot. That is a lot. So we need to go into and look at what those trees are. You made a statement that none, if I heard you correctly, none of the specimen trees along Tiger Tail are being removed. Is that correct?
That is correct. The specimen trees along Bayshore Drive are being protected. There's no
Bayshore Drive. Okay, so what about Tiger Tail?
In Tiger Tail, the majority of removals on Tiger Tail are invasive species and fruit trees. I'd
like to challenge that for a second, because if you look at the chart, there's a lot of red circles, and the purple circles are the fruit trees, and the prohibited circles are the orange trees, but there are a lot of red trees being removed on Tiger Tail. And if I look at some of the sizes of those, they're pretty significant. And you had mentioned also that only, I think you said 2 specimen trees in good or fair condition are being removed in the entire project. Is that correct?
Fruit trees. Out of the 26 fruit trees that are there, 2 of them are in good condition. All the rest of them are in poor and fair condition. Therefore, we're proposing to remove and mitigate for them.
And Commissioner, I'm not trying to confuse the conversation, but we also have Lisa Hammer as our arborist, who really did the evaluations on a lot of the trees, or all of the trees in poor condition. And if you were okay with it, and the city clerk could promote her, she could answer possibly some questions that Elizabeth may not be able to answer, only because Lisa did the initial evaluations of a number of those trees that are being removed/replaced. And I'm not trying to play arborist, but I'm just trying to offer another resource for you.
Thank you. I have the chart, and the chart says which trees are good and which trees are poor.
Okay.
And
just offering another resource.
I'll just pull out 3 trees alone. So that it's 690, 506, and 461. Those are 3 mango trees. All would be considered specimens over 18 inches. One's 42 inches. The 2 mangoes are 25 feet and 28 feet. And all of them are listed in the good category, if I'm not mistaken.
If I may say, and Quatisha, please correct me if I'm wrong, But fruit trees, even if they are over 18 inches, they're not considered specimen trees.
I just said that. Yeah, I agree with you.
Mm-hmm.
A fruit tree is not necessarily a specimen tree. And a specimen tree doesn't mean you're not allowed to remove it. A specimen tree simply means it gets a higher level of scrutiny and more attention is given to trying to preserve the tree rather than remove it. Can you build around it, or do you need to move it? And yes, it's true, fruit trees don't fall into that category, but tree number 690, for example, is a 42-inch mango tree. If you can picture what a 42-inch tree is, and that's just the diameter, not the circumference, the diameter, that is a tree that size, the age of a tree like that, I can't even imagine. And most of those mango trees are being removed for the parking lot, it seems, because most of those purple pictures are. And what was explained to me in my briefing on this issue is that they're being removed because kids may have an allergy to mangoes. And I just hadn't seen that, definitely not in our code, but I didn't know if that was a school policy or if there's an actual danger or risk to kids. But we're removing 25 mango trees, and many of very significant size, to make this a school so that kids who might be allergic to mango aren't exposed to a mango tree. I really didn't know that was an issue, but
here,
Commissioner, before Elizabeth jumps in, Commissioner, this is a little bit off topic, and I'll just take 30 seconds. I've been working with both as a parent and a legal representative on a couple other school expansions, and believe it or not, what you just mentioned, arborists have suggested, because of whether it's the peanut allergy or food allergy of children, we have gone that route in other school expansions, and I'm happy to give you examples of it because of that same exact issue. But Elizabeth here is the expert, so I'll be quiet.
I have a quick question. I want you to help me understand this. So the whole fruit tree thing. So fruit trees can be removed without any issue. I don't want to.
You have to mitigate for them. You remove, but you have to mitigate, even though they're not counted as specimen trees. You have to mitigate.
And by mitigate, do you mean replace it with a tree that is similar?
So in this case, what we're doing, and part of the whole concept of the design of this, and really focusing on the preservation and enhancement of Coconut Grove, the idea that we came in with very strongly was, if we're going to remove a tree of that size, and we need to make sure that we're replacing for something that we know it's going to be enhancing the natural community. And there's all of our trees that we're proposing for this project are native to the area, and that's the main goal. And Commissioner Russell, just to go back to you, when we walked the site, we went, I want to say, like weeks to the site to see what was there and to do our jobs as landscape architects. And for us, the best thing to do is to keep as many trees as possible, because it just makes sense, right? And from the beginning, we talked about how we were going to preserve and fill in the gaps where it needed to be, so that this could look like a project that had thought into it. Along Tiger Tail, the issue with it is that, yes, they're really big trees, but all of them are intertwined, and they're growing out of the wall, and they are almost, some of them are really leaning onto the street. And so we went one by one with Lisa, and we photographed, and we looked at the arborist report, and we went back and forth, and how we can remove some of them that were in bad condition and keep the really healthy ones and native ones, like the gumbos, that even though they're on the wall, we know they're strong enough to stay there. And how can we complement with new planting in the right place at the right distance? So a lot of thinking went into replacing what is not supposed to be there with the right plant material.
Understood. But when you do that initial survey,
Commissioner, I think, as far as I know, and Elizabeth, correct me if I'm wrong, Quatisha has been involved in this process for quite some time, and to the extent she can be, a voice of, understanding why some of the decisions were made, perhaps it's helpful to hear her perspective on behalf of the city.
Well, and she's here, and I'll ask her some questions because but first for Elizabeth, when you do that initial survey that takes you all that time, you're not, if I understand correctly, you're not simply walking the property, seeing what's healthy, what's not, what can be preserved, what's not. You're doing it in the context of a building plan and design to see what fits with that as well, right? So there is an effort, if a building is to go in this area, to either relocate or remove trees that'll interfere with that building. Same thing with a parking lot or an entrance or the flow. So I understand what you've done. You've tried to preserve what you can that is in context with what you're trying to build, and then mitigate by planting new. And I think you all have done as good an effort as you can with what you're trying to do. If you're trying to remove all the mango trees because you don't want kids to have them, you've done that. There's 25 mango trees going away, but the mitigation tree is a 4-inch tree. So this is something to think about. Non-fruit trees that are specimens, that's anything over 18-inch, that is meant to have additional protection from our department and from your development side. There are 11 specimen trees being removed, not relocated, but removed, that are not fruit trees, that are meant to have additional protection. And so that's a lot. These are big, old trees. And so the question then before us then is, despite your very responsible efforts to mitigate and make it aesthetically pleasing, is this the right project for this property if it causes that much removal of that much specimen? A 4-inch tree, no matter how many you plant, will never recreate within our lifetimes the character of what's lost from 11 specimen trees on the property. So that's just, I have some concerns on the trees. It seems that the by the code and the letter and the number, you're insufficient to the on-site mitigation using the 4-inch trees. And so you're having to pay an additional amount into the tree trust fund, which is also legal by the code. Is that correct?
Correct. Yes.
Okay.
We will. The idea for the tree trust fund is so that the money gets put in, so that the city and us they decide where these trees could be planted within the community, where they could very well thrive. And one of the things I would like to mention, if I may, is when we first started doing this project and we started to hear the opposition, and we clearly understand that why wouldn't you, if you're taking out 100 DBH, why aren't you putting back 100 DBH? And it's very easy for us to get a plan and put in and jam in there 180 trees, because we could potentially do that. But that's not responsible. One of the things that we really looked into was these specimen trees that we're seeing, and that we actually went and looked at each one and took pictures of, and they're huge. And you're right, they're probably 190 years old, but the condition that they're in is terrible. It's, per the
Well, let me stop you there, because the ones I want to concentrate on is 430, a 50-foot tamarind tree that's in fair to good condition. 450 is a 50-foot tamarind tree in good condition. These are very big trees, and that gives me some pause, because I see that they're in the way of the building footprint that you want to do, and so they've just got to go. So it's concerning that those weren't built around, and the plan wasn't altered to go around them. So,
and Commissioner, there were so many specimen trees, and I don't mean to speak for Rich because he's right there and ready to go. There were so many trees, particularly tree 460, that we designed the entire campus, if you will, or Rich. I don't mean to take credit. Rich designed the entire campus around trees. That there were, yes, some specimen trees that we weren't able to responsibly relocate on site. We followed the city rules and regulations. If you're asking us to, take a look at one or two more as like a condition of approval or whatever, or relocate them in a specific area, i.e. Kennedy Park or something close by, listen, I'm happy to have Elizabeth or Rich, and we haven't even talked about this, but I'm just going to throw it on the floor tonight. Yeah, we can take a look at putting them in a close by area because they are big trees. But, you know, I can speak for Rich, but of course Rich could speak for himself. He did his darndest, if that's a word, to design the campus with minimal impact to these. So Rich, please, or Commissioner.
It's not necessary. I get what you're saying, and
jump in just because she really truly is the arborist, and she just has a couple of things to say that I think it's important that we give her a voice on this. Is there any way that she can jump in really quickly?
Of course, but I just want to say the reason I brought this up and shined a light on this is that when you made your presentation,
yes,
it's almost like a marketing brochure for the good side of what you're doing, but we really need to see the good, bad, and the ugly. And there's no opposing side here that's shining a light on the downside of this, and there is one, and it may be still worthy of accepting the appeal, but nobody's showing us that side, that those 11 specimen trees are not being relocated and they're not being built around, they're being simply killed.
Well,
and so
Commissioner,
you need to listen to
the Commissioner, I'm sorry, Mr. Chair. Don't we have staff that could serve as a counterpoint? If Commissioner Russell has a concern about an opposing side, if staff is recommending it, then why don't we get our tree expert to come on and give us her perspective?
This is where I've gotten all of these details. I've gotten them from staff.
Well, but I want to hear. Maybe you got it, but I haven't. So if there's a different point of view, I want to hear it from our staff. Our staff is recommending this, that we vote a certain way. Then I want to hear staff reasoning for that, not the appellate.
And if we could, and I apologize, Commissioner Diaz-Del-Porte. And if there's a nearby location that makes sense, that Elizabeth and Lisa Hammer, that we can take those trees and keep them alive, we're certainly willing to do that. In the grand scheme of things,
Mr. Chair, if I may, because I think we just stick to go point by point, right? So we get there at the end. We need to get there. If Commissioner Russell is alleging some things, I think I will, and I want to hear from the appellant. I want to hear from our staff what their perspective is to what Commissioner Russell is saying. So I get the right information. I think information is important to make informed decisions, right? So, Mr. Chair, is our city manager on? Is Quatisha on? I guess that's the person that we need to hear from.
Quatisha's there.
Yes, let me hear from her to what Commissioner Russell is saying, through you, Mr. Chair, of course.
Good evening, or good morning, commissioners, and everyone. It's Quatisha Ogun-Toyinbo Rashad, City Miami Planning Department, Chief of Environmental Resources. So I have had the pleasure of working with the applicants on this project, and it's a very ambitious project. And we, of course, were very concerned about the impacts to existing tree canopy, as we are when we are reviewing all projects when it comes to preserving our natural resources. What we see here, what was presented today, does show a number of trees being impacted. However, the trees that are being impacted, I feel, especially from a professional standpoint, that these are trees that, based on their condition of being in fair to poor condition, their location where they will be upon development is not the most favorable location for them to be. The landscape plan that you see before you, we have worked with the applicants, and we feel it is almost the best outcome, the most favorable and practical landscape plan, a sustainable plan that you would want for the type of, the scope of work or the type of structure and activity that will take place on the Carrollton site. Meaning that you do not want to overplant. You do want to provide enough space, green space for those trees to thrive. There are trees that are in buildable areas that we worked hard with the applicants to try to have them redesigned to the best extent possible. Some of those efforts were explored and they were successful, some not so successful. When it comes to the fruit trees, there are significant sized trees. I believe there's even one mango tree in good condition. We try our best again to transplant and preserve as much as we possibly can, definitely depending on the species. When it comes to fruit trees, it's not the most favorable or ideal situation to transplant fruit trees, especially if they are in fair or poor condition. The risks start to outweigh the benefits. So we look at what the canopy replacement will be. And if it is a better course to replace them with native, viable, sustainable trees, and will offer more of a benefit to the city of Miami, then that is the route that we would take, and that is what was done here.
So you think they're offering, the appellant is offering a better course?
Then to preserve trees that are
in fair and poor condition. And so the better course is to do what the appellant is doing, rather than try to preserve trees that are in fair to poor condition that will probably not survive.
Correct. Correct.
I'm sorry, I interrupted you. Continue.
But that was pretty much in the majority of, not the majority, but almost a significant amount of trees are prohibited species. While they may seem large and provide a sense of canopy, we do want to encourage the removal of those and replacement of native trees as well.
So Commissioner Russell spoke. How many did you say, Commissioner Russell, were trees that were being removed? What was the number you gave?
So there's 11 specimens that are being removed.
How many total trees, though?
Total trees is 60, I believe.
You gave us a number.
64 trees, excluding the 54 prohibited ones. There's 64 trees being removed.
Talk to me about those 64 trees, Quatisha, please.
So the 64 trees is a mixture of fruit trees, a mixture of, you have some natives, there aren't any native trees that are in good condition that are being removed.
Okay.
They range from a size 2 inches in diameter up to 30 or 40 inches.
2 inches in diameter?
Yes, 2 inches in diameter up to 30 or 40 inches in diameter. Okay. And if they are in good condition, the best effort is made to relocate those. If it's impractical to relocate them, then we will remove them and replace them. But none of those are specimen trees. None of those are of significant size, or we would feel, in our professional opinion, is of significant value worth preserving. So that means they're pretty much in poor condition and on a decline where there aren't mitigation efforts that can be done to bring them to more of a viable state.
Talk to me about the 11 specimen trees that Commissioner Russell referred to.
Yes. So those 11 specimen trees, I want to get the exact for you. So there are, again, as I said, there aren't any in good condition.
There aren't any.
There are
no 11 specimen trees, right?
No specimen trees that are in good condition being proposed for removal.
So the 11 that Commissioner Russell referred to are on fair to poor condition.
They are in fair to poor condition. They are of significant size, but they are fair to poor condition. So you have.
Continue. I'm sorry.
Okay, so of those 11, about 7 of those are specifically in poor condition. You have live oaks, 2 ficus trees, and 2 other hardwood trees, a Royal Poinciana, that are in poor condition. You do have 2 live oaks that are in fair to poor condition, but they're grafted together along close to the wall, where it's not favorable to preserve those 2 trees based on its condition and its location. And then you have 1 in fair condition, which is a ficus, a native ficus, which is like 38 inches in diameter. This one is in the building footprint. So it was a challenge or not practical to redesign around that particular ficus. And when it comes to relocating those, it's even more of a challenge to relocate ficus trees. So the last resort was removal and replacement.
Quatisha, if there were a...
Tell me, well, if I may finish, Commissioner Russell.
I believe I was actually the one that was originally talking.
But I was recognized, I believe, by Chairman Hardiman to ask. I
It's
called
fine.
on her.
It's
I
fine.
called
Go
on
ahead.
Quatisha to come to ask some questions to rebut some of the arguments you were making, or at least to get on the other side of the story. If you'd like to go ahead, I can come back.
I have a very specific question of what she just said. So before we get beyond that, I wanted to make sure we don't get lost. So go ahead, please.
So explain to me, Quatisha, in layman's terms, what it means for a tree's lifespan when you say it's fair to poor condition. Well, what does that mean for people that don't understand the world you live in?
Sure. So when we say a tree is in fair to poor condition, that it's typically meant that it's on decline. It's an older age and is in decline. There are most likely defects, there's decay, there's no canopy, there's very scarce canopy, there's been some damage to it. And so there's a risk that it either may fail soon, or there are some mitigation or some corrective efforts that should be made to bring it back to life or bring it back to a healthier state. If not, it's just on a decline. It's at its mature rate, it's at its mature age, and it's in decline.
Okay.
That's fair to poor.
Okay, Commissioner Russell, if you want to go ahead, Mr. Chair, I would like to come back if we can to Quatisha, maybe ask for some more questions.
Quatisha, if there were a fair 22-inch oak tree next to a wall on a single family property, let's say a 5,000 square foot lot in the Grove, and a developer wanted to come in and build a large building there, but that 22-inch fair condition oak tree, not in the building footprint, but next to a wall, the canopy would be interrupted by their second floor. Would you allow them to remove that tree?
If the canopy is going to be removed by that second floor, if the structure cannot be redesigned, of course, our first effort is going to have it to remain in situ in this location.
Even if it affects their building design or whatever.
Right. So by virtue of exploring the effort or making the effort to preserve the tree, that means we will consider and see how the building or the proposed development can be redesigned to adequately preserve that tree. Meaning there wouldn't be any canopy loss. That's the first effort we would explore.
So the reason I bring it up is I'm wondering if we're looking at this property in the same way we would, just because that tree in the picture of the totality of this entire landscaping plan isn't as crucial. Are we willing to give up some of these specimen trees that we would otherwise force a developer to keep because the totality of this plan, this design, does have so much other additional plantings and tree preservation and things like that. Because I see we're doing a bit of a balancing act. There's a lot of good in what they're planting, but I don't want to lose sight of what we're allowing that we might not otherwise allow on a single family lot, for example, if it was just that one tree, one lot kind of thing. Is that a fair assessment?
Yes, that's fair. And we also want to take into consideration, the use of that space and the frequency of the space to ensure that not only we'll be preserving this tree, but we will make sure that there is a safety component there and that it remains safe.
Thank you very much. That's all I had on the trees. And before we move on to the other commissioners' questions, I'd just like to wrap up, and I'll be done asking questions or speaking, if that's okay, Mr. Chairman. Thank you very much, Quatisha, and thank you, Elizabeth. I appreciate that. We were told both by staff and by the appellants that nothing within this HEP board appeal can have to do with traffic. And I just wanted to put on the record some questions I have about that. Because there was an interpretation given by our legal department about two ordinances passed by this city commission, one in 1988 and one in 1999, on this property, the actual designations of this property. And ordinance number 10494 in 1988 specifically says in section 2, it is hereby found that this zoning classification change, and then it gives a list, and item G says, will not create or excessively increase traffic congestion. And the interpretation I received from the law department is that, yes, these ordinances stand, but they do not apply to this appeal or a prospective application for a new use on the structure or historic preservation certificates, because this was a snapshot of a moment in time of when this ordinance was passed, that the designation at that time would not create or excessively increase traffic. But the verb in this section 2 letter G is will not create traffic. It didn't say this zoning classification is found that it does not create in this moment. It says will not create, meaning that if we designate this, what happens on this property will not create excessively increased traffic. So to me, that implies that it's been preserved based on the fact that it will not create excessively increased traffic. So it seems that maybe we should be able to say that the certificate of appropriateness, the certificate of approval, could have to do with these original designations. Because in 1999, Ordinance 11876 says in section 2H the exact same thing. It's hereby found that this zoning classification change will not create or excessively increase traffic. But we're not going into that at all in this presentation or in the staff recommendation. And so that concerns me a little bit, because it feels to me that we should be considering these original ordinances. And then finally, I know that staff does recommend this, and it says that in our agenda. It says findings, planning department recommended approval. But then when it has the finding for the HEP board, there's some verbiage here that I just don't think we should write it this way when we create our agendas, because it doesn't say that there was a denial. It says motion to approve resulted in a tie vote of 4-4. I don't think we have ties in our city commission votes or in our lower boards. A tie is a denial. And so what it should say on our agenda is that the finding of the Historic Preservation Board was a denial. It can show us the vote. And I like to always go back and look and sometimes even call a board member to say, hey, why you vote this way? What were you thinking about?
Let me hold on.
But Commissioner Russell, with all due respect, and I was hoping you were going to bring this up. The HEP board at first hearing requested some additional information, 2 or 3 items. Maybe Ethan remembers the exact ones, I don't. And we came back the next month, and they closed the hearing, by the way. And we came back the next month with a board member that had not been there the previous month. And that board member, we furnished the additional information. That board member said, I don't really care. I'm opening this whole thing back up.
Ryan, please.
We had a whole
what you're saying is irrelevant to what the point that I'm making.
No, it's not.
I hear what you're saying, and there was a story that got to that vote and why it was a tie.
Gentlemen.
But please, the simple point that I'm making is very important.
Gentlemen, let me
Just give me 10 more seconds.
But what you're going off, you're going off in an explanation of the tie. I don't need that. I'm simply asking my staff if there is such a thing as a tie vote, or if our agenda should reflect a denial of the HEP board. Because a tie vote, just tell me if I'm wrong, is a tie vote a denial or a tie? Do we have a tie in our
Francisco?
Well,
Chair, thank you.
Go ahead, Francisco.
Thank you, sir. I believe the very next sentence, Commissioner Russell says, in fact, I'll read the whole sentence in context, tie vote of 4-4, and then in parentheses, numeral 4-4, constituting a denial. So yes, we're clear that 4-4.
It does not say that, Francisco. I'm sorry.
I'm sorry, I'm reading from my summary sheet. I apologize.
Neither PZ1 nor 2 say constituting a denial. It's just a matter of rhetoric, and it feels that by claiming it's a tie, it's almost like a neutral ruling, but the ruling is a denial, and I just think it should say what it is so that we can.
I don't know if that's true. Like for instance,
I don't think it's true either.
Like for instance, we had a vote earlier today, and the vote was about the should we grant or deny the intervener status, right? And I said to you, if I vote with you, Commissioner Russell, it'll be a tie, 2-2, which means that the motion that was made to deny failed. That motion fails, right? That was a motion. Yes. But moreover, if you made a motion, if you did it in the
reverse,
if you said I move to approve it, and I voted with you, that motion would also fail.
Of course.
Yeah.
Right. So that's why I said that we will be in this position where it's kind of like limbo.
Stalemate.
Yeah, you haven't made it
right, but the end result is a fail, right? And so you have to call it.
The end result is not a recommendation. It is the end result typically is like not a recommendation, I would imagine, from there. And it's also and so the planning department is saying that they constitute that as a denial if they don't recommend. Is that what you're saying?
Right. They simply don't say the words denial anywhere.
Well, but the fact of the matter is that it's 4-4, and I think.
Can I say something?
I'm sorry, Mr. Bailey. I'm sorry, Mr. Chair. Can I be recognized?
Please, you're recognized.
Thank you, sir. The fact of the matter is that it's 4-4, and where the reason why it's 4-4 may not matter to you because it doesn't serve your purposes, Commissioner Russell, for your argument. I would like to know the reason of why it happened and what happened at the HEP board, because I want to make an informed decision. So I have no problem with Mr. Bailey explaining to us.
Oh no, I agree with you, Commissioner.
Not in a long, convoluted way, but in a short, succinct way. What happened? So if you could do that, Mr. Bailey. And by the way, I'll stay here till 6 a.m. I'm used to Tallahassee. I'll go back to Tallahassee. I love to go back to Tallahassee, especially at this time. I'll tell you. We used to go till 4 or 5 in the morning. So to me, it's 30. But I would like to know what happened.
I'm just closing, and I won't say another word.
Mr. Bailey, I would like to know what happened.
30.
Yes. Hold on. I would like to know.
30 seconds.
Let me just finish quickly. I would like to know what happened because I want to know the history, the trajectory of how we got here. I don't want to have a debate about traffic. We're not here to have a debate about traffic. It's not intellectually honest to have a debate about traffic now. That debate can come when we have the other conversation down the line, but not now. We're here to have a different kind of debate. So talk to me about that debate and stay on task about that. What happened at the HEP?
It's 30 seconds, and then I will defer to Francisco and Warren. We went back for the second hearing. They opened up the public hearing when they said they wouldn't. We did our whole presentation again. And then there was a vote, Commissioner Diaz de la Portilla, and there were no conditions suggested. There were no things suggested. There was nothing on the record. I would pose it to you if you asked Francisco or Warren why the vote was 4-4. There's nothing on the record. It was 4-4. There was nothing negative said. We did everything we were asked. There was nothing. Could you do this? Could you do that? Could you? There was. I think if you asked Warren, he would say to you, there was no discussion as to why the vote was 4-4, but based on HEP board procedure, a 4-4 vote was a denial.
Okay.
Thank you. So my only point in that, it wasn't to disparage why it was a tie or that it was a tie, but simply that a tie is a denial and that our agenda should reflect when the HEP board denies something. For whatever reason, we can do that discovery, and that's fair enough. But I I would prefer some consistency, because I know in the past when HEP board, it says you were approved or denied. We don't really talk about ties, but it does say the score, which is fine. We always say the score, 4-4, and that's fine. So that just concludes the questions that I had. I really appreciate all the time you spent on this, Ryan, and you're helping me understand what you all are trying to achieve with the school, because I certainly see that a lot of effort has been done here to create a thoughtful landscaping plan, a thoughtful preservation plan for the structure, and a thoughtful plan for the corridor. So thank you.
And Commissioner, without cutting off the chairman, which I think I just did, I apologize. I appreciate all the time you've spent with us over the last few weeks, and I just hope we have the opportunity to continue this conversation over the next several months. I'm done.
One of the things I want us to all remember too, especially when it comes to boards and motions and such, is that a motion can be changed ever so slightly, and it changes the result of whatever you're considering. So, for instance, that motion that went 4-4 might have been a tie, which they consider as denial, but someone could have very easily on that board modified his motion, and it could have been a 3 or 2 difference, and it's a different motion, and that could pass. So whether or not someone actually goes and makes that attempt is another thing. But essentially, that's why I kind of don't look at it as a 4-4, essentially as just a denial. I mean, it's de facto you just didn't finish the agenda, and we're not going to hold it on that, that lower board. But motions are funny creatures of our imagination.
I hear you.
So here we are. Is there any further discussion on this issue, Commissioner?
If I may, on the legal opinion that the Vice Chairman brought up, if I just could clarify, these items that occurred under 11,000 and also 9,500, they were both zoning issues. They weren't HEP issues. So I did tell the Vice Chairman, though, that I was going to have a frank conversation with the planning and zoning departments to see if there are any of those zoning requirements that may still be part of our Miami 21 ordinance when the exception comes around. But for purposes of this item, they don't have any significance. So I just wanted to place that for the record. Then with regard to traffic, I did want to clarify that traffic, again, is something that's super important to discuss at the exception portion of this hearing. When this comes, if it comes back for an exception, that's when that would be discussed as well. So I just wanted to clarify those things for the record. And Vice Chairman, I have not forgotten about that discussion, but it's at the zoning portion, and we'll follow up again. Okay.
I appreciate that. And question before we vote on this, is this contingent? If this were passed today, is it contingent on being passed with the zoning, or when we vote on the appeal for the HEP issues, that they stand alone regardless of what happens with the zoning? Or is that up to us?
I believe Francisco can answer that. It could be a condition, but Francisco can elaborate further.
You're recognized, Mr.
I could answer if it helps. That's one of the draft conditions, that if you accept staff's recommended conditions, it has a condition tying it to the other application.
Got it. So it was a staff recommendation on the department approval that this be tied to the zoning.
Okay.
So if this passes today, but the zoning doesn't pass, this reverts. Is that correct?
That's my understanding. I'll defer to Warren, but that's my understanding. That's correct.
In other words, Mr. Chair,
you recognize, sir.
In other words, if we don't pass this today, they could come back with meeting requirements that, for example, that I'm not satisfied with what I've seen. But they could come back and we can pass both of them or deny both of them, the zoning change and the reversal of the headboard.
I'm not sure I understand that.
Well, let's say that we vote against granting the reversing of the decision. I mean, we vote against it, reversing the decision. That doesn't close the doors to you. You can come back, and you can come back with a proposal or with the information, for example, that I want to know. I mean, this was a beautiful, beautiful presentation, but there's certain things that I stated to you and to everybody else that concerns me. But if you come back, you can come back and present also a request for modifying the decision of the health board of rejecting their decision, and at the same time changing the zoning to what allowing you to build whatever you want to build. I mean, this in other words,
sorry, go ahead.
By voting against this doesn't close your doors from coming back again.
Well, I guess my understanding is if our appeals this evening are voted down, Commissioner Reyes, that the only way we would be able to come back to you would be to pursue this in a court of law, as opposed to refining our plan, so to speak, and that if the court of law were to vote in our favor, then we could come back and ask for, something further. Instead, what we would prefer is we would love your support, although I understand we may not have your support this evening on this particular application, which is just about the preservation that Rich Heisenbottle and our landscape architects have done, and that we know we have work to do on our next application, which is the exception, where we have zoning issues and potential interveners and things like that. So I'm not sure if I mean,
Victoria, could you clarify that for me? Because as I was informed, I mean, and this is they can come back again with the request and then satisfying some of the concerns that we have.
Right. So I think there are a couple different questions floating around. So what I think I'm understanding is, if right now the appeal, if the appeal is denied, they have either the option to appeal to the circuit court, or they have the option to regroup and go back to HEP with a new application. Those are like the two options, I think. Then the other thing that was asked, and I think that was confusing everything, is the tying in of some of this item, that nothing would happen, like that these items could be approved with conditions. However, nothing would happen until you find out what would happen with the exception. It would be tied in. And I believe Francisco says that there are draft conditions to that effect. So there were a lot of different questions. So I hope that clarified everything.
So they're not standalone items?
They are standalone items unless, in this particular case, unless the applicants agree, or the draft conditions that have been proposed, or you as the commission can tie it into the exception, like saying, okay, we're granting the appeal, we're reversing, but you're not going to do anything until you get your determination on the exception. You can tie it in as the commission. You can do that condition as well.
And my name, Mr. Chair, what about the, Vicky, this is for you. What about the argument that Mr. Bailey is making that, well, he lives to fight on Monday or fight another day, I guess. If we move forward, we'll still be able to have debate on all these issues, right? When we have the zoning debate.
Right. Yes. I think what he's saying is that if you grant the appeal, then he can go back and talk to the community and try and work out some of these issues.
So that's what I'm saying. So then my question will be to Mr. Bailey, realistically, I've received, as we all have, all the emails, and there's been a lot of back and forth in this debate. Realistically, is there a midpoint here? Is there some middle ground? Are you going to get there?
Commissioner, let me say two things. Without the benefit of speaking with my clients right now, but I think I can speak at liberty in front of all of you. I have, Olin Kalkas, who's the chair of the headmaster at Carrollton, is on with us right now. And I will repeat to you some of the things that I said to Commissioner Russell earlier this week. I have worked with Carrollton for the last 12 to 15 years. I have helped Carrollton build buildings on their campus. I have helped them overcome issues with their neighbors. I will do, excuse my language, my damnedest to go to the community and come up with 10 to 12 to 15 things that we can do to help be collaborative and community building, whether it's doing something at Kennedy Park, whether it's extra police officers, whether it's something I can't even think of right now. So my answer to you is, I will do whatever I can. And if I think that it's you, Commissioner Diaz de la Portilla, or Commissioner Russell, or anyone in the world who is suggesting something reasonable to Carrollton do, and that they say no, I'll resign, and they can find other counsel. I know them. Wait. They are going to try and do the right thing for the community. So the short answer to your question is, I want that opportunity to do the right thing for the community. I think, in my heart of hearts, having done what I've done in Miami for 20 plus years, I think we can get there. There may be some people that I can't get, that we can't, to support us, but I think I can get 98% of them. Just give me that shot. That's all I'm asking for. That's all the schools ask.
You have, okay, I'm sorry, Commissioner Reyes.
Okay, go right ahead, and then I will answer that.
We had a number of neighbors that when they tried to become interveners in this debate, that they showed maps of how the property was abutting the villa and within 500 feet and all that. But I'm sure there's a whole bunch of other neighbors, right? I'm sure that those 4 or 5 neighbors are not the only neighbors.
Of course.
Have you made any attempt to talk to all these other neighbors to see if there's other neighbors that perhaps there's more of those than these neighbors?
I will tell you, we did make attempts back in 2018 when we first signed a contract to buy the property, to meet with all the adjacent neighbors, and we met with all of them. It wasn't me. It was Olin Kalkas, who's the headmaster, and Tucker Gibbs. Some of those meetings went very well. Some of them, they asked us to move the building. Some of us, they said, no matter what you do, we're not going to be in support of this. All I'm asking tonight, give me a shot to go do it again.
Sure.
That's all I'm asking. And I may not be able to get there, but give me a shot to get there, and we'll do whatever we can to do it. And some of them, I think we will get there. I don't know if we'll get 100% of the people who spoke in opposition to the school to say we love the school, but I know that we can figure out, Commissioner Diaz de la Portilla and Commissioner Russell and Commissioner Reyes, we may not get your support, but I'm telling you, I know, and Olin, I would love for him to speak. I know that we can figure out ways to make, tell me, go ahead.
I'll do one more, Commissioner Reyes. I promise I'll end it right here. At least for this segment. I promise it'll be the last one.
Okay.
Why didn't, even though it's not a debate about traffic, it's not a debate about zoning, why didn't you bring some of those people today? Why weren't those neighbors that may like this project not come before us today to strengthen your case or make a stronger argument on your behalf? Why is that the case?
Can I?
So I'm sorry, go ahead. Before I answer, go ahead.
No, I'm going to add that, and then you're going to have a chance to answer. We have met, and I have met with many people from Carlton. I stated my concerns. My concerns are the residents. My concern is traffic. My concern is a plan of when when the children's and the coming to school and leaving school. My concern was how the community was going to be affected. And I stated it not only to you, to everyone that came to my office. And I said it once, and it was a month ago. And I was expecting that when you were making that presentation, that you were going to bring at least a blueprint of a plan, that how you were going to avoid having the community being so, I mean, being affected. Being affected. Correct. That you had talked to the community, to the people, and you had said, okay, what does bother you? I mean, it is can we do alternative hours of dismissal and entry? I mean, something, but I didn't see anything. The only thing that I'm with all due respect, you might mean, and you're a man of your word, I'm not putting that in doubt, but it's a give me a chance. And I told you to your face, and remember, I said, this is my concern. This is my concern. My concern is traffic, how that is going to be a traffic in a road that is already congested. How that is going to affect it. Have you talked to the residents? Go and get the residents to understand that you have a plan. If you have a plan, that all those, I mean, concerns that they have, they are going to be. I mean, you're going to work towards getting into, trying to solve them. But you didn't do it. You see, that presentation is beautiful. That is a beautiful presentation, all of that. But what concerns me, I didn't see it. What I expressed to you, right, face to face, everybody that came to my office, you see, that was not addressed. Not even it was an intention of addressing them. And not only did you didn't bring anybody that, if you have some people that they were in favor of the project, they didn't. I mean, you didn't bring anyone. And the only thing that we have heard is, let me talk to them. Give me this, and then we talk. And I told you, and I told everybody, listen, bring me a plan. I mean, this is not the first time that I have dealt with schools. And all the schools that I have dealt with, they have come to my office, and they have come before the commission and said, listen, this is the plan that we have. We are going to, I mean, the entrance is going to be, we are going to alternate, or we're going to do this, or we're going to have police officers, and we're going to, you're saying, sure, now because I'm mentioning it. I cannot vote like this. I mean, that's my only concern. And believe me, sir, I don't have anything against Carlton. As I told you, my sister, my older sister, she went to Cuba. She went to El Sagrado Corazon, and she graduated from El Sagrado Corazon, and still she meets with her old classmates. See, I don't have anything against that. And you are Jewish, I'm about Catholic, and I was educated by nuns and priests. So I mean, it's nothing to do that. But we have a neighborhood. We have a neighborhood that we have to protect to. We have.
I agree with
traffic,
you. I couldn't agree with you more.
Traffic jams from 3:30 in the afternoon. You see, we have traffic jam in that area. And I wanted to know what were the measures that you were going to take in order to ameliorate the traffic jams or avoid it. But I didn't hear anything from that. That's why.
Can I respond? Can I respond just quickly?
Yes.
So, Commissioner Reyes, Commissioner Diaz de la Portilla, I hear everything you're saying. We met after our applications were denied at the HEP board. We had applications pending, the two that are being appealed tonight, this evening, or this morning, and we had staff recommendations. We met with a few of the residents who voiced concerns. And then after we did not receive a positive vote, we reached out again, and we met with two of the three people that were trying to intervene. Tucker Gibbs and I, and Ethan and I met with them, and they discussed what we could do, and we said, here's what we could do, and they never got back to us.
Did you meet with me?
And I'm sorry?
Did you meet with me?
I did not meet with you personally, no. I did not.
Okay. I remember meeting you.
And no, and from a strict application perspective, we decided that our head of school, who I think has met with a couple of you, that he was the best person to communicate our message. I've said to Commissioner Russell, and Commissioner Russell, please jump in if I've misrepresented what I'm about to say. But we're really here about preservation of buildings and trees. And we think we have a strong application. We know we have hay to rake or hay to make, whatever the phrase is, at 1 o'clock in the morning. And all we're asking is for a chance.
That is, look, Mr.
Hold
Bailey,
you all to
Mr. Chair, Mr. Bailey, and that's really, I think, your strongest argument. I think you probably should have tried to meet with all commissioners, because really it's only 5 of us. That's not that hard to meet with all 5. But that's probably your strongest argument. We're here to discuss the environmental and the trees. We're not here to discuss the zoning, the school, the traffic. You have a traffic study. There's obviously ample. If we have another opportunity, you have another opportunity. It may not happen, but if you have another opportunity, at least you'll be able to go through that traffic study. I've heard all sides of this debate from different people. What I've read in the papers, what I've read from, I met with Mr. Arguez and a couple of other, and some neighbors also that are concerned. So I've heard both sides of the story, not from you, but from others. So to me, it's pretty easy the way my thought process works. I can separate the debate we're having tonight with the debate we can have on Monday about the zoning and a debate about the school and the traffic. To me, it's 2 separate debates. It's a HEP board, it's a 4-4 tie. It's a 4-4 tie. There's a lot of things that I heard that happened at that HEP meeting that, that were somewhat questionable from my perspective. So to me, that's not something that's going to bind me as a commissioner, what a particular board does, because of some kind of bias that exists among one particular member of that board. And so to me, that's important, but it's not binding. It's not something that's going to drive my decision-making process. So today's debate is about trees and the environment and all the different issues that we're talking about, right? That are relevant to today. I have no problem from my perspective of giving you the opportunity to fight, to live to fight another day, to come back at another debate from my perspective. If you make, number one, if you tell me that you have a realistic opinion that you're going to get there, you're going to make some progress. If you're going to bring us other neighbors, because I'm sure there's a lot of other neighbors that agree with your position, that you're going to make some strong arguments down the line about why it's not really a major traffic problem because it's the same kids or the same families that are going to Carlton. It's a brother or the sister that goes to Carlton. I've heard those arguments too. If it's not really, if you can make a lot of solid arguments, I'm sure it could be made if you have a good traffic study and if you can bring family members of girls that go to Carlton that could say, no, my son is going to go to the new school, and the headmaster come in and say, by the way, of the 350 kids, is that what it is? 350 kids? Is that what we're talking about? 335 kids. Well, the 335 are, 180 or 200 of the brothers are likely to be the brothers of the girls that go to the girls' school. There's a lot of arguments to be made. We've heard them, and I've heard a whole bunch of them. And we can have those arguments if you live to fight another day. To be intellectually honest, I think the debate tonight and the vote tonight should be about the issues that are before us. Not about zoning and not about traffic and not about how many kids and what you're going to build and if you're going to build it. That's a different argument. So from my perspective, I will likely, and we may be a tie vote here tonight, maybe not, but I'm going to vote to give you the opportunity to fight to live another day. That's what the way I'm going to vote, because I believe that they have an opportunity to make. I think you should be given the opportunity to make that argument. You should also keep in mind that it's really tied into a lot of things in my thinking, in my thought process. It's really tied that I want you to go out there and find neighbors. I don't care if 100 people or 200 people send emails that are pre-written and that doesn't intimidate me or change my vote or maybe vote one way or the other. The same way we have people read from scripts all the time, because I want to know what the general neighborhood thinks, right? So if you have the opportunity, perhaps you could come back and say, well, you know what? Here are 20 neighbors or 25 neighbors that want the school or like the school. And these are the parents or the kids that are going to go to the school and they happen to live in the neighborhood, right? All these things, I think you didn't do a good enough job. You should have anticipated this argument today, because you know that unfortunately these arguments all get mixed into one debate where it should be 2 or 3 different debates. So I think that you probably could have done a better job in getting some neighbors to come today and testify and say, look, those are not the only neighbors. I only heard from 3 or 4 people. How many were there, Commissioner Russell, that came today to testify before us? What was a public comment?
As interveners?
Yes.
Yes, interveners, how many were there?
Apparently it was 24 was one
Right.
group, and then 3 separate ones. So total of 25, I guess.
25. So, Mr. Bailey, if you couldn't find 25 people in Coconut Grove that agree with your position, I think you have a problem, right? And so I would think that you would, go try to find them, and maybe they come in and say, we disagree with these other 25 people, because that happens in neighborhoods all the time, right? Some people may want the school, and I'm sure some do. So from my perspective, that's where you failed in making your presentation, because everything is, at the end of the day, unfortunately, in politics and the decision-making process, no matter what time it is, even if it's 1 o'clock in the morning or 1 o'clock in the afternoon, everything gets mixed. And the public pressure is, hey, it's about the traffic. Hey, it's, neighbors don't want it. And the picture is painted that it may not be the completely accurate picture, but it's been painted. So you have a lot of work to do. If it gets past today and you get to live to fight another day, or Monday, as you say, get to Monday, then, I hope that you would make a concerted effort to make sure that you have neighbors come over and testify before us and tell us why it's a good idea to have the school. So those are my thoughts. I'm going to vote with you today to help you, to give you the opportunity to come back to us, you and the school and the headmaster and the whole Carlton family, which, by the way, it's as Commissioner Reyes said, it goes back to Cuba, where my parents come from. It's a school that a lot of Cuban families send their girls to.
That's right.
I went to Belen.
I don't have the
almost not almost. I dated some Lourdes girls, but I dated some Carlton girls too. So so it was kind of like it's a tradition in the Cuban culture to go to Carlton, or to go to Lourdes, or to go to Belen. I ended up at Gulliver, but it happens. But the idea is that Carlton, and I'm probably better off for it. But anyway, that's a different conversation. But the idea that Carlton has a boys' school for the brothers of the girls that go to the school, I think it's a nice concept. It's a beautiful thing. It's a tradition in our city in Miami. It's a Cuban American thing, from my perspective, in many ways. So for that and many other reasons, I'm gonna give you a fair shot, and a second shot. I'll give you a second shot. You. Coming back with a stronger argument of why we should do this. I'm going to vote with you today, okay?
Thank you. I appreciate it, Commissioner.
I just wanted to propose then a motion for wording based on everything that you've said. If you want to tie in the items.
I have a quick question.
I think Chairman Chairman Hardiman still hasn't given us his opinion.
Yeah, I have a quick question. There's one conclusion that says that the application has not demonstrated compliance with Chapter 17 entitled Environmental Preservation of the City of Miami Code of Ordinances. Staff finds that this request does not comply with all applicable criteria and is found that the proposed site improvements do adversely affect the natural environment and importance of the subject property. Now that's different from the historic preservation of the Chapter 23 entitled Historic Preservation of the City of Miami Code of Ordinances that says that the Secretary of Interior standards. Staff finds that this request complies with the applicable criteria and finds that that the request for special certificate of appropriateness for demolition, restoration, alteration, new construction does not adversely affect the historic, architectural, or aesthetic character of the structure. So basically, the structural part says that it is in compliance, but then the environmental preservation part says that it is not in compliance. Am I reading that correctly, Mr. Adams?
There was actually an updated report prepared. I believe that was done after the applicants came back to us with some changes to the design. I believe both of them are uploaded into the information.
Okay. So then both were found to be consistent with what their testimony is saying.
Ultimately, yes.
Okay. This is one of those things where I try to follow the laws as best as I can. And from the information that was put on the record today, this was about preserving one, a building, and two, the protection of an environment. And it seems to be that from what was presented and from not only from the applicant, but also from our staff, is that this does just that. And so, you know, I will tread lightly. I'm not going to try to go further than that in my analysis of this. And so I'm going to base my decision from there. I don't know how we're going to move forward. I mean, right now you have, you know, what Commissioner Russell wants to do as far as the motion. So I think we should find some motion and then go from there.
Thank you, Mr. Chairman. So if it's about the structure, the trees, the bluff, I think the structure itself is well preserved in this plan, but the surrounding buildings that they're proposing are imposing on the environment, imposing on the bluff, and imposing on the trees more than they would be if they were just left alone or if they were developed around. So I think it fails in that respect from a historic preservation. The bluff is the most obvious one to me that is in violation of Chapter 17. I really feel that bluff is not being preserved or left visible to the transit corridor. And so I would move to deny the appeal.
Okay. So it's been properly moved to deny the appeal. Is there a second? Motion fails for lack of second.
I will move to adopt the appeal.
It would be to grant the appeal.
I'm sorry, to grant the appeal, That's what I meant, sorry.
And do you want to do any tie-in?
No.
We discussed?
No tie-in. To grant the appeal. We'll do the tie-ins later.
If I may, through the chair.
You recognize.
I'd like to suggest if the body were to move to grant the appeal, and I think this is amenable to the appellants, that there also be a proviso included that allows only work that is remedial or curatorial in nature to be done on the site in furtherance of this application, but no actual construction or other disruption of the site pending the issuance of the exception if that should pass.
I'll amend my motion to include whatever Francisco said right now.
Could I? If I could word what I think he's trying to say, and you could tell me otherwise, Francisco.
Okay.
Commissioner, grant the appeal, reversing the HEP approval of the COA with conditions recommended in the staff analysis, and no building permits for the certificate of approval shall be granted unless the school use is approved by the commission.
No, the last part is not what we're doing now. That conversation is a later conversation. The first half of what you said.
The problem is that, just so you know, then they could go forward with permitting and they could take down trees and do all that. I want you to know, like, what would happen if you don't tie it.
I can vote for that.
So let's tie it in. Read it again.
Okay.
Say it again.
Grant the appeal and reverse the HEP decision to approve the COA with conditions recommended in the staff analysis, and no building permits for the certificate of approval shall be granted unless the school use is approved in the exception, by the commission the next time.
I understand. Okay, that'll be the motion.
I'm sorry, terribly sorry, but they should be allowed to undertake curatorial or in remedial work, meaning if they have to prune the trees, if they have to repair windows, they should be allowed to do that. We would want them to be able to do that, just not in furtherance of the school use, no new construction. No.
So improvements, not any destruction.
Thank you.
Right? Improvements and not any destruction. Additions, not subtraction. Right? Okay, we'll add that to it. Is that okay for you? Okay, we'll do it that way.
Okay.
That's a motion.
That is the motion. Is there a second?
Yes, sir.
Is there a second to the motion? Okay, so that motion dies for lack of a second.
So we
Chairman,
go home.
Chairman, the last time we were here at 1:30 a.m. on a historic preservation appeal, I think you, me, Victoria, and Todd were the only ones that are on this dais again, was St. Jude. I'm having flashbacks. 1:30 in the morning, historic
So
preservation.
you have flashbacks too. I'm not the only one, you see.
Can they come back again? You see, with, they can, since we haven't made a decision, can I propose that they come back and then,
I move to defer. I would then move to defer the item
okay, come back and bring all the requirements that we have.
and bring neighbors and bring, so I will move to defer the item.
I'll second that.
Commissioner Diaz de la Portilla, to what date?
It was the first meeting in September.
September 10th, sir?
Yes, sir.
Understood.
It's been
With
Is there
the condition they come back with some neighbors
Come back with
is there
a plan.
with a plan, a better plan. So
A
that's
better
that's my
plan,
motion.
and-
I think, yeah.
And take, you see, excuse me,
if
sir,
I
you
may-
see, in baseball terms, do you like baseball? You see, a plan that you have touched all the bases, okay? You touch all the bases of all the concerns that we have here. Just think that you are in Fenway and you're gonna touch all the bases. You're gonna go around the horn, okay?
Well, if I can have just a minute, I'm not sure I'm going to be able to do that in this environment. I don't want to suggest that I'm going to be able to do that and not live up to your expectations or your business. I'd rather have a vote tonight that frankly
that's
doesn't
not
go
gonna
in my
happen,
favor.
Mr. Bailey.
That's not gonna
Mr.
happen.
Bailey, there's a stalemate. So this is gonna happen. What's gonna happen is we're gonna move, I move to defer, Commissioner Reyes as second of that motion. We'll vote on that and you come back and then we'll have another conversation. A different date.
Could we perhaps, I mean, again, I don't mean to be argumentative, but
You're not.
we've, you know, when I came before you at the end of February and asked to defer our appeal, I got pushback. And then when we came back for another deferral last month, given the world we're living in, which I totally understand, it's difficult to do these types of situations. So,
Mr. Bailey, you need to have situational awareness. It is 1:29 in the morning. It is a 2-2 tie. You're not gonna get anywhere. The best place you're gonna get is a deferral so you can live to fight another day and have a different debate. So you need to know where you are right now.
Question?
No.
Can I ask one more?
No, you can't. You can't. I mean, we're done. You're just, you're going in circles. It's a 2-2 tie. The commissioners cannot.
Not even. I mean, it's like if we couldn't get a second. If we don't get a second,
no one. One side couldn't get a second. The other one couldn't get a second. So it's a tie. We're done for the evening. There's a motion on the floor to defer, and Commissioner, Mr. Chairman, I call the question.
Been properly moved.
Could we just do the early? Could we just do the early September meeting?
That's what I said. That's a motion. September 10th. We already made. That's part of the motion. So September 10th. You'll be back. It's only a month. It's only a month. It's only a month and a half. So we'll see you soon.
You have a lot of work to do, sir.
You have a lot of work to do.
You have another school appeal on September 10 plus the budget, just reminding everybody.
That's fine. That's fine. There'll be another late meeting. Maybe we'll make it time certain in the morning. We'll figure it out.
You're
Chairman will
accustomed
decide
to
that.
this late meetings, man.
But I love the late meetings. But before we go, when we come back in September, we may very well have a county commissioner presiding over this body, and not a city commissioner.
That's right.
So I don't know. He'll look down on us. He'll hook up with Jimenez and pass mandates and tell us what to do. I don't know. Well, maybe he'll still be a city commissioner. All right. I don't know. We'll see. We'll see if he changes. We'll see if he changes September 10th. But I know we all wish you luck, Commissioner Chairman Hardiman. You're going to win. You're going to make a great county commissioner, and my brother looks forward to serving with you and a great future together. I've enjoyed the time I've had with you. We'll do another farewell before you leave us. I know you're not leaving
Oh,
until
hell
November,
yes.
but I wish you luck in your election on August 18th.
Thank you, sir. Thank you.
It's same here, Commissioner. I mean, it's been such a pleasure to work with you. And remember what I told you outside of City Hall? That stands.
Remember, understood.
And by the way, I represent Alapata, and that's in your new district. So let me know whenever you want me to go knock on doors or do a robocall for
Absolutely.
you, whatever you need. I'm here to help you. Because I think the county would gain a lot from having you.
It will benefit a lot. Yes.
Absolutely.
Thank you. I really appreciate it. I really do. All right, everyone. There's a motion, there's a second to defer this item. Seeing no further discussion on the item. All in favor, say aye.
Aye.
All against? That motion carries.
And Chair, just for the record, that was for PZ 1 and 2.
That
Yes,
is
sir.
correct.
Mr. Chairman.
To September 10th?
September 10th. Listen, guys, be
Chairman.
safe, and enjoy your vacation, right?
Mr. Chairman.
Be very safe.
Mr. Chairman.
Motion recognized,
Mr. Chairman.
Yes, yes.
There was a pocket discussion item on COVID-related response in the break while we're gone. And I'm very, very concerned as we don't have guidance on what metrics we're going to be using and where the city manager is taking the city with regard to the potential for a shutdown or not, what metrics we're studying or not. And I know it's 1:30 in the morning. We've been here for 14 hours, but I'm very concerned about where we're going from here forward. I'd just like to be able to communicate to our public what that plan is. And so I just had a few questions for the manager and I wanted them on the record.
Okay. So, Mr. Manager, is he?
I think the manager just left my office on the way over to his office. Should be there in about 2 minutes.
Yes, I thought he went home.
Okay.
No, he's here. He was sitting in front of me here.
Oh, my God.
But he'll be there in about 2 minutes.
Thanks. I really appreciate that. And it means a lot that everybody is here. I have a lot of respect for this body for really putting in the time, and it's clear that everybody cares very much about their job here. So I'll just wait for the manager.
As we wait, Commissioner Russell, I don't want to do any Carollo thing on you, but are you going to cut your hair in August? When you come back September 10th?
Don't get that.
I just said you're going to cut your hair.
Hey, you might get another complaint, you know?
No. He knows I'm playing. But I think it's time. I think it does make you look younger.
It's like,
it does make you.
for me
I like
doing
it. It makes
this
you look
all
younger.
night. You know, Carollo's wife may cut his hair, but my wife's a veterinarian, so the only thing she shears is poodles, and I don't want to look like that.
You got to be careful with that.
Be careful. No,
The only person who gets a break is Barnaby, because even when I grew my hair out, you guys beat up on me. So
Barnaby has the best hair.
yeah, Barnaby does all kinds of things with his hair.
Is he sleeping or is he around?
No, he's there. He's there. When Chairman Hardiman let his hair grow out, he looked like a 12-year-old on the dais.
Well, he looks very young. He still looks very young.
Who's that little kid on the dais?
And Vic, I'm very happy you're looking better because you were a little bit.
So I have a fan. Apparently, it was like 76 degrees. I had the jacket.
You turned red.
I turned red. My husband brought me a fan, so I'm much better now.
Good.
I was gonna pass out.
Mr. Noriega, you're recognized.
He's back.
I'm back.
Mr. Manager, thank you.
Sure.
We understand the numbers right now, and we understand where we're getting stronger on mask enforcement, and I think that's great. We're trying to avoid a shutdown, but what will be the trigger that makes you decide so that we can forecast to our businesses and our residents a week out what number they should be looking at? And if we hit that number, whether it's hospitalization beds, ventilators, ICU, a combination, so that if a dire decision is made, it's because we have to, and people can understand it and back it, and it won't be a 24-hour notice turnaround.
So just for point of reference, we're having, we'll call them meetings 3 times a week, Mondays, Wednesdays, and Fridays. We have a morning meeting with the Department of Health. In that meeting, we have the biostatisticians from FIU, as well as University of Florida. We have epidemiologists from Baptist and from the county. And we basically run through all the key statistics. Migoya from Jackson leads the sort of conversation off with regards to his internal network, because he has those same 3 meetings as well, Monday, Wednesdays, and Fridays in the afternoons with all of the CEOs of the various hospital networks in Dade, Broward, and Palm Beach counties. And what they're doing is they're taking and analyzing all of the numbers as it relates to occupancy, ICU numbers in terms of the increase or decrease, what they call R-naught stats, which are the ones that balance the ratio between the input and output in a hospital, discharge rates. Also looking obviously is ventilation utilization and the percent positives. Those are all the statistical data that we're evaluating in terms of the metrics that we're using to evaluate at what point things become critical. Also embedded in that, and it's a process that's been engineered through the contact tracing process the Department of Health is engaged in, and they have roughly, I think, they're up to about 600 contact tracers now. But they have a survey that they initiate as they engineer
in the county. In the county,
Department of Health, correct?
They have 600 tracers.
Yes, working in
the county,
correct. And they're basically contact tracing, and as part of that contact tracing process, they've engineered a survey by which they're actually tracing back the assumptions made on where they think they might get sick, what industries are specifically the most that are sort of we'll call them the hot spots, and then they're getting survey results. We review some of that data as well on Mondays, Wednesdays, and Fridays in our morning calls. So one of the things we've realized, I think, from a contact tracing point of view, is that for the most part, I think because people are so mobile now, that the contact tracing part is becoming very difficult because people really don't have any sense of how they're getting it. So that's become a little bit of an issue for us in terms of analyzing that as well. But we are getting really good numbers in terms of the hospital data. I think that's the thing we've really kind of focused on. I also left out the death rate and the percentages related to death versus ICU occupancy numbers. And so one of the things we're sort of focused in on is what's the hospital capacity? At what point does the hospital situation become, we'll call critical? And using that as a principal gauge by which we either continue to roll back or take the advice to roll back, or whether we just maintain the status quo. In our last couple of meetings, what we've noticed is all of the key trajectories are starting to get to a point where they're starting to level off. In other words, we're not having those dramatic increases like we did before. The percent positive rate has sort of hovered around 20%. At one point, it was as high as almost 30. And so we've watched it, especially in the last few days, we'll call it 6 to 7 day period. It's starting to kind of traject back towards a leveling off period. Obviously, we have another call in about 7 hours. And at that call, we'll have obviously updated numbers relative to the last few days. I think a lot of us are starting to at least feel some optimism as it relates to the mask order, and obviously the additional order that impacted occupancy utilization in dining in restaurants, that they're starting to have an impact. I think us ramping up enforcement, as I've referenced before, significantly is also going to help a lot. And honestly, our hope is that trajectory continues to move forward. We've also had a representative from the school board, and so the district, on our last call, to kind of give us some input as it relates to what our Miami-Dade County School District is thinking in terms of its reopening plan. And when you map out the numbers at the rate we're starting to see things level off and maybe start to work their way back in terms of the percent positive, we kind of project that for us to get to a level that brings us back below 10%, which was where we were, was sort of the key threshold that was really issued by the CDC. And to get us back below 10% in terms of percent positive, based on the slope, the way it's progressing now, we're probably a good 30 days out, somewhere between 28, 29 days out if we continue the current trajectory. That being the case, that would put us almost spot on to the opening of schools, right? Because the tentative school opening date is August 24th. So there's going to be a lot of hard decisions that have to get made relative to school openings. We also have, by the way, the FIU biostatisticians are doing projections based on school openings as well, and what that impact may have. They weren't ready to present that data at our last meeting as well. But that data is coming also. So that kind of gives you sort of a snapshot of what we're looking at in terms of the kind of information we're reviewing and analyzing. We have yet to really get to the one single matrix that is sort of the be all tell all in terms of us making a decision. We're sort of going to have to evaluate all of them as a whole and kind of see where we end up in terms of the decisions. We've kind of made, the hope is that we have a number of cities on those calls. So it's not just the city of Miami, it's Coral Gables, it's Hialeah, it's the city of Miami Beach, Key Biscayne's also on that call as well. So Miami Gardens. So there's a number of cities that are all involved in those calls. Our hope is that we end up analyzing and making recommendations when the time is right and we feel it's relative, whether it be to close something back up if things continue to maybe progress to be worse, or if they get better to open things back up. Our hope is that we're making a recommendation to the county and that the county is ultimately going to be the key entity that drives the decision-making process with the cities sort of all in concurrence.
Mr. Manager, I have an issue with that because you're saying we'll make that decision when we see those numbers and we decide, but there is no specific matrix. I feel like if I threw a few numbers at you as a hypothetical, you'd know in your gut what you'd have to do in that moment. If I said we were at 40% infection rate and we had 0% ICU and the death rate was up to this, you go, okay, we have to do this. Why? Sorry, my battery's low. Why can't we forecast that right now? Because this virus is going to go one of three ways: up, level, or down. And you got it handled. If it levels or down, we're fine. But on the up is where I want to worry about. And I want to be able to forecast because the county failed in their rollback. They failed because they communicated it poorly. They didn't forecast it well. And they didn't show why they were targeting what areas. They didn't have data behind it. And that worries me. So.
And the rollback or the reopening?
The reopening was fine. When they tried to roll back the restaurants and they had to change their rules 3 times in one day was because nobody accepted their rollback. The gyms didn't accept it. The restaurants didn't accept it. The people didn't accept it. I want us, if we have to take a dire move, that our public buys into what your decisions are. And I believe the only way to do that is through proper communication and forecasting and data. And so I believe in you. And I'd like you to work on that over this next week to say, in these worst case scenarios, here's what we would do so that we can start to think of that worst case scenario. And the last thing I'll leave you with, and I'd love to hear the opinion of the other commissioners, if you feel that there is a vector that is more of a transmission risk than others, and let's look at house parties, for example, mass gatherings in houses, because people are trying to find ways to have fun and together, and they're getting together in their houses. If that is a true potential vector in your mind, I've asked for a legal interpretation from our city attorney if we could enforce against that. And I believe the answer I've received is yes. I know Fort Lauderdale has implemented something like that. And so I'd love for you to have that tool if you feel it's appropriate during this coming month. If that's a vector, that's a risk to us and our numbers are still going up, that you take enforcement in that area.
I'd be interested to see what the city attorney had to say about that.
It is a yes. We can enforce. It is legal to enforce. The problem is that it's hard to enforce because, as you know, if they don't open the door, you're not knowing who's in there. You're not knowing if it's family. Is it 10? Is it 10 Cubanos? Is it a party? But at the end of the day, obviously, if you're able to get in and you're able to talk to somebody and they say, yeah, I'm having a Getty and whatever, you can obviously tell people, okay, you need to go home, your curfew, you can enforce if you get enough information, but it's hard. I don't want to mislead you that it's easy peasy. but it's
No, the information I had been given when we first looked into it based on the Broward order was that, yeah, you can enforce it. The issue is always going to be how you gain entry to the house.
exactly.
Because
What
they
if
have
they're
to allow
violating
you
the noise
entry into the
ordinance?
house.
If they're violating the noise ordinance.
Yeah.
Right, noise ordinance,
Yeah.
of course, you could close down a party, of course.
Absolutely,
but
but-
normally they're not violating anything. But yes, you can enforce. The manager is saying it correctly, as I just said. You know, it's hard sometimes to get on the information, but it is a tool that you can use in the citation process if you wanted to.
Vicky, one thing that I have learned about neighbors and all of that, there's still some Airbnbs that are being rented for parties. And I don't know if we are keeping track of them, because that is probably, it's one of the places that it is rented by young people. And they as a matter of fact, that I had one about a couple of blocks from my house, and it was checked, and I reported it, and it was checked, but I don't know if we are keeping track of Airbnbs and particularly the ones that are single family homes.
Yes, there's actually been an uptick in the reports. I feel really bad for Adele. There's been an uptick in the reports of Airbnb parties and events, and just because people are home, so they notice people coming in and out, people renting, people with their suitcases, more so than before. When you were at work, you wouldn't know what was happening sometimes. So yes, I'm sure Adele would be able to run that report. But I do know, and remember, we just filed a lawsuit on one in Belmead. We've got a clerk's default in one in your district. So we are enforcing, except for the 7 named plaintiffs in our Airbnb case. We are enforcing when we're told about violations, and when we're able to prove, get the people, get witnesses, get the Airbnb VRBO information, we're able to take them, obviously, to code enforcement or court, depending on the situation. So yeah, there's a little uptick.
Okay, Mr. Chair, if I may, I have a question for our manager. Tomorrow you have a phone call with the League of Cities, and is Mayor Jimenez on that call?
He's doing those calls along with the chairman. I'm not on those League of Cities calls.
So the chairman is the president of the League of Cities, and I'm a member, so I'll probably be on the call also. But Mr. President, Mr. Chairman, what's on that agenda? We're going to have, besides a conversation about getting us our fair share of the $500 million that he got. Besides that conversation, is there any other conversation about any additional measures that he plans to take in August while we're in our break, and they're on their break too?
Well, that's what the meeting is about. The meeting is our regular meeting when he gives us updates about what he is planning for COVID-19 related issues. We were supposed to hear back from him today at 5 o'clock yesterday at 5 o'clock about whether or not, or what plan he was going to submit to the Miami-Dade County Commission regarding the COVID-19 relief dollars. I don't think he got back to us. And so the League of Cities is going to do what it believes is in his best interest of his membership. So that includes the city of Miami to garner support to have those dollars distributed to the cities so that we can use it to combat COVID-19 and so really supplement our budgets to fight what we're doing. I'm sorry, it's late, but to fight the COVID-19 issue. So tomorrow we should hear more about it. I don't know if he's gonna. We may or may not pose a question about the Relief Act dollars, but usually the 3 o'clock meeting or the meeting is about just the virus itself and government and how we're acting.
Right.
Okay, guys. Good night.
So you'll have a better idea tomorrow as to what the county's thinking is, right?
Yeah.
Correct.
Okay. Okay. Thank you.
All right, gentlemen.
Thank
All
you very
hearts
much.
and all minds clear?
Yes.
Yes, sir.
All right, this meeting is adjourned.
Good night, everyone. Thank you.
Good night, everyone.
Take care.